Good morning. We want to welcome each and every one of you to the fifth hearing of the Select Committee on Police Reform. I'm Mike Gibson. I chair this committee. I want to pause for a moment and thank our speaker, Anthony Rendon, for giving me this tremendous opportunity for appointing me the chair of the Select Committee on Police Reform. He did so in 2020. I've been chairing this committee since then. Before we begin, I must note of some rules that we have to follow regarding physical distancing. So I would ask that you please bear with me as I recite these rules. Due to the continuous COVID regulations, we are practicing physical distancing here in the hearing room and throughout the Capitol building. So we are only able to have a limited number of people watching and participating in the hearing room in person. Excuse me. We are also required that each person wear a mask at all time and also practice physical distancing being maintained by all members of the public testifying, whether here in the room or in the video conferencing center, if we have one. I'm not sure we do, but in the video conferencing center, if you do not have a mask, a mask will be provided to you. Because of our space limitations, we have some committee members sitting on the dais, a few members sitting in the audience in the first row. For those committee members who will be speaking, we ask you to please approach the microphone that's provided, that's behind the plexiglass. We ask that you not touch the plexiglass. We will have someone lower the microphone to your desired specification if, in fact, you need it. We have a few different options for the public. When we reach the public comment portion of the agenda, I would ask that any member of the public here in the room please approach the microphone. Again, please do not touch the microphone. We will lower it and adjust it to what specifies your comfort level. In addition to that, practice social distancing. Once you finish testifying, we would ask that you please exit the meeting room or please return back to your seat. Again, practicing physical distancing as well. Also, we want to adhere to the elevators. Two people one person in the elevator at any given time. And those who are in addition, those who are testifying outside the hearing room, again, we ask that you, again, practice social distancing as well. Witnessing in the video conferencing room here in the Capitol or at the remote testifying station located on the Capitol grounds and in a few other locations throughout the state. Practicing social distancing, wear masks, and follow those guidelines. In addition to that, for those who would like to dial in and also testify, we have provided a monitor telephone service for the public. The call-in number for the hearing is area code 877-692-8957. Once again, if you would like to call in and provide testimony, the call-in number, once again, is 877-692-8957. And the access code is 1315-4202. Once again, it's 1315-4202. You can also find it on the Assembly website TV screen. The operator will place you in the queue and then give you further instructions from there. If you're calling in, we would ask that you please limit it. Background noise, if you're doing even live screen, we want to make sure that your testimony is coming through clearly without any distortion, any background noise that may be surrounding you. So with that, I would ask that you please govern yourselves to these housekeeping rules as we move forward with today's hearing. For all of you in attendance here and online, thank you for participating today. You, like me and other members of the Select Committee, are committed to seeking justice in communities we serve. In its first 4 hearings over the last year and a half, the Select Committee has begun work to create a comprehensive reform. One of our overall policy goals has been to hold bad actors accountable and improving the relationship between the community and law enforcement. Thus far, we have learned about the history of police reform efforts in California and how to improve recruitment and training. We have explored the right balance on training and accountability. And we're here, we've heard from victims, we've heard from victims of police brutality. We have heard from families of such as Angelo Quinto. Angelo Quinto was a Navy veteran from the Bay Area who was tragically killed in custody, similar like George Floyd in Minnesota. We will continue to say his name and other names of individuals who've lost their lives. As a result of the great work my colleagues and I have done as well, excuse me, here in the legislature, who leads their own charge, we have passed historic police reform laws that will improve and save so many lives in this great state. These reforms include prohibiting law enforcement gangs, a ban on restraints that leads to positional asphyxia, a decertification process, more transparency in police records, a duty to intervene is required, higher standards for aspiring law enforcement candidates who wants to go into law enforcement. Specifically, new officers must be at least 21 years older and have a college degree. California is leading the way, but we have so much work to do in the future. Our work will be done here to protect Californians and families. We want to do everything that we can in our power to rid out those bad actors, but also want to make sure there is a better relationship between law enforcement and our community. Today, we will be accessing the Peace Officers Procedures Bill of Rights, also known as POBAR. POBAR affords police officers who have committed misconduct certain protections while under investigation. We will hear from experts in academia, lawyers who represent the rank and file officers, police chiefs, and others to inform members of the Select Committee and the public. Thank you all for being here today. I want to thank my colleagues and those who are watching from wherever you are and participating in today's hearing. For those in the audience, you will also have an opportunity to participate during the public comment section on the agenda. That will be after all the panels have presented and questions from my colleagues. Then you will also have an opportunity to participate as well. Before we begin, I want to recognize my colleagues who have taken time out of their busy schedule to joining us for a few opening comments, and please introduce yourselves. We want to start with our Majority Leader, Eloise Reyes. So please feel free.
Thank you. And good morning. I want to begin by thanking our chair, Mr. Gibson, for leading us on such an important topic. I also want to thank the Select Committee staff for organizing today's hearing, and thank our panelists who are joining us to talk about such an important issue. We've heard from some of them in the past, and it's always been very insightful to hear from them. So I look forward to hearing from them again today. The current climate on police reform gives us the unique opportunity to bring forth change and awareness with public support. With events that have occurred over the past few years, as mentioned by my colleague, it is our duty as committee members to question the status quo and find ways to increase police accountability and bring justice for all Californians in an equitable way. It's really all about community and law enforcement and protecting everyone while working together. I'm also eager to hear from the panelists from a wide array of backgrounds as we discuss the Police Officers' Bill of Rights and the future of police accountability. It is fitting to have individuals from law enforcement and from the legal sector to help facilitate the conversation. We are committed to provide the accountability and protection for our community and for law enforcement as well. I look forward to the hearing, and I look forward to hearing from all of us to figure out how we can best ensure police accountability and public safety while upholding civil rights and, most importantly, human rights.
Thank you very much. Next, we'll have Assemblymember Lackey.
Thanks to all who have organized this gathering and this opportunity to discuss a very important matter. I came not to talk, but to listen, and so I look forward to what's going to be expressed today. But just as a point of interest, 20 of my 28 years with the California Highway Patrol was spent being a frontline supervisor. So I'm fairly familiar with the Peace Officer Bill of Rights. And I hope after this discussion, people will realize that it's rooted in just fairness and investigative process. Thank you.
I want to thank my colleagues for your comments and your remarks. And I'm very excited that you, again, once are here. We know that other members will be joining us. Just also to a point of view, most of our, if not all of our witnesses will be viewed virtually. So we have no one who will be coming in the room to testifying in person. We will be looking at and causing everyone to turn to your monitors for those who will be joining us virtually. In addition to that, again, I'm excited to be here. I'm excited that we're at this place to create a more robust conversation and understanding in this space, because I think it's absolutely important that we discuss POBAR and provide clarity and information so that the public and also ourselves as policymakers have a better understanding. Me as a former police officer, I understand it. As Mr. Lackey has indicated, hopefully that us, as we move forward and answer questions, everyone else will have a better understanding as it relates to the Peace Officers' Bill of Rights. So with that being said, we want to welcome our panelists for joining us today. I would ask that you take 10 minutes, and within those 10 minutes, if you can please introduce yourself and then commence to providing your presentation with us. We will have a robust discussion on the history, fundamentals, and perspective of the Peace Officers' Bill of Rights. And the first panel is Maria. And I need your help if you could just pronounce your last name. Associate Law Professor at the University of Minnesota Law School. So thank you so very much. If you can please help me pronounce your last name, I would greatly appreciate it. And just give us your introduction and commence with your presentation. And thank you once again.
Of course, and thanks so much, Chair Gibson and committee members, and thanks for inviting me to speak with you today. So my name is Maria Ponomarenko. I'm a law professor at the University of Minnesota Law School. I'm also co-founder and counsel at the Policing Project at New York University School of Law. The Policing Project works with police departments, with community groups and elected officials to promote a more equitable, just, and effective approach to policing. We've worked now in more than a dozen jurisdictions, including New York, Chicago, Nashville, Tucson, and here in Los Angeles. Of particular relevance to this committee, we've also drafted model state-level legislation on various policing issues, including the sorts of accountability concerns that are the subject of this and prior hearings of this committee. I've been asked today to provide some background on the Peace Officers' Bill of Rights in order to set the stage for the discussion to follow, which I also am really eager to hear from the other panelists about. So the Peace Officers' Bill of Rights basically gives officers a set of rights and protections, mostly having to do with a disciplinary process. So POBAR's core provisions kick in whenever an officer is under investigation for misconduct. Some of the provisions basically just codify kind of traditional due process protections, such as the basic requirement that officers have notice and an opportunity to be heard before discipline can be imposed. Other provisions potentially impose a much more rigid set of constraints on misconduct investigations that go beyond what other public sector employees enjoy, at least as a matter of state law. Now, California is not alone in having a Peace Officers Bill of Rights. There are currently 20 states with these sorts of statutes. Maryland, which was in fact the first to enact a Police Officers Bill of Rights, repealed its provision earlier this year, leaving 20 other states with these sorts of provisions in place. California's POBAR was enacted in 1976 in response to two overlapping sets of concerns. The first was the perception among line officers that police disciplinary processes were often arbitrary and grossly unfair. So officers routinely complained that the likelihood and severity of discipline often had very little to do with the seriousness of allegations against officers, but was instead driven by favoritism, by media pressure, and other factors that were outside an officer's control. The perception was that some officers got to operate with impunity because they were well-liked by their superiors, and others were subject to discipline for minor infractions that would otherwise be ignored. Officers also expressed concern about the treatment during disciplinary investigations, including in particular the use of threats and other coercive techniques in order to get officers to confess. And so POBAR was designed in part to address these sorts of concerns by adding some degree of procedural formality to the disciplinary process and ensuring that officers had an adequate opportunity to present their defense. I start there because I think it's really important to acknowledge the very real concerns that drove the enactment of POBAR, some of which rightly or wrongly persist among officers to this day. At the same time, I think it's equally important to recognize that this push to kind of regularize and formalize the disciplinary process was also a response to demands for greater police accountability during the civil rights movement in the 1960s, and perhaps more importantly, the rise of civilian review boards and the push for greater community control over the police. In other states with POBAR statutes, we actually see much stricter limits on civilian involvement in the disciplinary process, which really kind of brings out this other side of the history of POBAR. California's POBAR does not expressly preclude civilian review, but this push for kind of stronger procedural protections and more formal constraints on police discipline was nevertheless spurred, at least in part, by greater public scrutiny of the police. And so perhaps unsurprisingly, California's POBAR includes a mix of fairly rudimentary procedural protections, along with a few provisions that potentially make it harder to hold police officers accountable for misconduct. Among the provisions that ensure basic procedural fairness is, for example, the requirement that officers be informed of the nature of the allegation against them prior to questioning. POBAR also requires that interrogations take place at a reasonable hour, ideally while an officer is on duty, and it requires that officers have an opportunity to take breaks during interrogation to attend to their physical needs. POBAR also prohibits agencies from, for example, requiring officers to submit to a polygraph, which again is a reasonable limitation given the many concerns about the accuracy of these sorts of exams. Other provisions potentially impose a more serious obstacle to accountability and are at least worth exploring in greater detail. So for example, POBAR generally requires that an investigation of an officer be completed within 1 year of when the agency learns of alleged misconduct, which means that an officer may sometimes get a free pass if an agency is slow to act. Statutes of limitation for other public sector employees, including in California, are typically closer to 3 years, which ensures that agencies have the opportunity to fully investigate all of the facts. POBAR also requires agencies to provide officers with a transcript of any prior interrogation of the officer related to the same incident before an officer can be questioned a second time. This provision, again, may make it a little bit more difficult to identify potential inconsistencies in an officer's story through multiple rounds of questioning, which is, of course, a traditional police technique. Finally, POBAR's various procedural protections kick in whenever an officer is being questioned about a matter that could potentially lead to discipline. And at least some have raised concerns that because this could potentially apply to supervisory questioning immediately after, say, a use of force incident, that this can make it more difficult for supervisors to quickly develop an accurate picture of what in fact occurred. That said, I want to underscore that California's POBAR lacks a number of the more troubling provisions that have drawn widespread criticism of POBARs in other states. So Maryland's Law Enforcement Bill of Rights, which was recently repealed, allowed officers to delay interrogation for up to 10 days, no questions asked. And this obviously was a serious impediment to getting a quick accounting of the facts. Maryland's Leobor also required that the person interrogating a police officer be a sworn officer themselves, which essentially precluded any sort of civilian oversight entity from investigating police misconduct. Minnesota, where I am, has a provision in its Bill of Rights which basically precludes any sort of civilian review by prohibiting civilian review boards from either making findings of fact around police misconduct or imposing discipline on officers. And Florida's Bill of Rights, which again has drawn widespread criticism, requires officers to get access to the complaint, all witness statements, and all evidence against them before they can ever be questioned in the first place. And this, of course, gives officers an extraordinary degree of leeway to construct their version of events based on whatever it is that the evidence purports to show. And so, against the backdrop of Leobors in other states, California's is somewhat more narrowly tailored to really address concerns about procedural fairness and to balance officers' interests against agencies' legitimate investigative needs. The last point that I just want to make is that POBAR is not the only potential obstacle to holding officers accountable, and eliminating potential provisions from POBAR would not necessarily mean that they would cease to be a problem in the state. So in states without peace officers' Bill of Rights, a lot of the same provisions are contained instead in local collective bargaining agreements, police unions. And in fact, collective bargaining agreements often impose much stricter limitations on the disciplinary process than even the most expansive police officers' Bill of Rights. So lots of collective bargaining agreements impose mandatory waiting periods before an officer can be questioned, or give officers access to all of the evidence against them, or prohibit any sort of civilian review. I've only done a cursory look, but it looks like there are at least some of these sorts of provisions here in CBAs in California, though it's hard to know just how prevalent they are. In the absence of a state-level POBAR, though, one might expect that these sorts of provisions would start to crop up with a greater degree of frequency. And so should this committee decide to propose amending or repealing portions of POBAR, my advice would be to approach the matter holistically and to ensure that these sorts of provisions can't just come into being back through local collective bargaining agreements. Thanks so much, and I look forward to hearing from everybody else.
Thank you so very much for your testimony. We really appreciate, again, the information you provided. Members, what we're going to do is we're going to have all the panels speak, and then we're going to ask questions. We've asked all the panels to please remain online with us. And then after all the panels have completed their testimonies and their presentation, then we will ask for a series of questions from an array of the panelists from members moving forward. And so with that being said, thank you very much. You could please stand by. Members, we invite you to please write your questions down, and so we can go back and refer to it and address it to whoever you choose. Next up, we want to welcome Cecil Rambo. He is the Chief of LAX Police Department, who's participating virtually with us. Chief Rambo, are you with us?
Yes, Chairman. Can you guys hear me?
We can hear you very well. Thank you so very much for joining us. We appreciate it. We ask that you take 10 minutes. In those 10 minutes, if you can please introduce yourself and then commence to sharing with us your thoughts and your testimonies on this subject matter.
Absolutely. Thank you guys for having me. And I've actually worked up in the Palmdale area, so I know Chairman Malecki. So I'm 36 years into law enforcement. I spent 33 of those years in the Sheriff's Department. I was assigned internal affairs twice at two different ranks as a sergeant and a lieutenant. I am currently the chief of police here at LAX Police Department. And as the professor noted, one thing I want to add is that this provision was also signed into law by Governor Brown, Jerry Brown, and actually supported by the ACLU at the time, and opposed by chiefs of police, ironically, back then. But I can tell you as a practitioner, as an investigator, as a supervisor of internal affairs investigators, and then as a command officer, I understand certainly the challenges that POBAR can have for us as chiefs of police. People kind of misunderstand the fact that the Peace Officers Bill of Rights and the role of internal affairs investigations are to simply find the facts and to separate the truth from fiction and put out the facts as they may before the body that's going to be determining the discipline. And then as we've progressed over time, there's often a development of a bail schedule, for instance, or consistency in a type of discipline. So if someone gets disciplined for, let's say, an on-duty traffic collision at a high-speed traffic collision, that they get the same amount of discipline that someone else did for a similar offense. I can tell you that as a practitioner, there are challenges to interviewing officers and deputies when you're doing investigations, particularly when there's significant uses of force or someone has passed away at the hands of an officer or deputy during the course of a use of force incident. And often here as you guys know, here in Los Angeles, there is the number of people that respond to significant uses of force has expanded from just merely the homicide investigator and the internal affairs investigator, but also the state attorney general's office, Office of Independent Review, or Inspector General. So there's a number of folks that come out and gather information to take a look at these particular cases. With that said, I think that as a professor mentioned, if the panel should decide that they would like to repeal this, I think we should caution ourselves because bargaining and having MOUs in collective bargaining can actually lead to much more frustrating and more challenges to doing law enforcement investigations. I think that if we're going to take a look at POBAR, take a look at each section, and be very, very cautious and introspective on how we're going to revise it or make any changes to the Procedural Bill of Rights. But in short, I believe that it's a law enforcement protection on both sides. I think it helps departments understand how to perform their jobs within certain boundaries without being officious. And at some point, we probably will talk about Liebarger, who was actually an LAPD officer who had committed a criminal act in which you have to, you cannot any compelled statements cannot be used in an administrative, any compelled statements cannot be used criminally. So you have to be careful by bifurcating criminal investigations or criminal allegations against law enforcement officers as opposed to administrative investigations. So, because they have a right to remain silent. So, as we get into these discussions, I'm sure Dave Mastagni will talk about those issues. But I welcome any comments and certainly will have some input as we move forward in this hearing today. Thank you.
Thank you very much, Chief Rambo. Appreciate your testimony in this space and appreciate you articulating some facts around POBAR and your history. Next up, we want to, first of all, I want to make note that we also have Assemblymember Kevin McCarthy. He's watching this virtually. He's on the committee, just notified me, let me know that he is watching this virtually and will be chiming in at a later point in time. We now want to move to another panel discussion, and we want to focus on how POBAR works in practice and when investigating police misconduct. Each panel will have 10 minutes to speak, and within those 10 minutes, you could please introduce yourself and then proceed with your presentation. We're happy to have, to kick us off, Mark T. Harris, a civil rights attorney with Ben Crump Law, who has joined us today virtually. Mr. Harris, are you with us? Mr. Harris? No, Mr. Harris, as of yet? Okay. Do we have a representative? Do we have Mr. Nastagny? David, are you with us?
I am.
Oh, fantastic. It's good to hear your voice. David represents, Mr. Nastagny represents rank and file officers who will be testifying around POBAR. And thank you very much. And you're free to begin to introduce yourself and also provide your presentation.
Thank you. My name is David Nastagny. I am a public employee labor attorney. My practice specializes in representing public employee unions and their members in all aspects of their employment, from contract negotiation for pay and benefits through the disciplinary process that includes public safety employees, firefighters, and law enforcement officers that we're obviously here to talk about today. If I could share my screen, maybe get some help on doing this. I do have a PowerPoint presentation. Let me see here. Can you see that, Mr. Chairman?
Yes. Yes, we can.
Okay. So I wanted to walk the committee through the disciplinary process in POBR and provide some context for its provisions. At core, the Peace Officers Bill of Rights, Procedural Bill of Rights, is really a codification of longstanding union rights to represent members during the disciplinary process. And before I jump into the details here, I want to point out a couple of things that are really important to remember. The Bill of Rights is something that happens during the disciplinary process, and it is just basic procedural representation rights is really half of it, and then the second half is a codification of constitutional due process rights. And all of these rights are, for the most part, found, as the prior speaker mentioned, in other aspects of case law and in other statutes. The remainder is a bunch of miscellaneous rights that are really things that happened over the time that the legislature corrected, like an officer not being allowed to wear an American flag pin, or an officer not being allowed to run for a school board position, or forced to take a lie detector test. The key thing, though, that is important to remember is that none of these rights apply to a criminal investigation. None of them are in any way an encumbrance on holding officers accountable, criminally or administratively. But none of these things apply. If an officer is accused of excessive force and there's a criminal investigation, or sexual assault, that's a criminal investigation, and the officer is treated just like any other criminal suspect. These only apply during the disciplinary process, and we're really only talking about procedural rights. So jumping right in, I know my time is limited here, to the administrative investigations. The gravamen of the protections under the Peace Officers Bill of Rights is basic information that any other union member receives in any kind of administrative investigation. The subject matter of the investigation, the names of the people that are conducting it, reasonable opportunity to get a representative, the opportunity to tape record it, the right not to be harassed, threatened, or coerced. And I want to juxtapose this with some of the other public employee statutes, starting with the NLRB, which actually doesn't apply to public employees. That's why we have all of the state labor statutes in California, where we're more progressive than some of the right to work states. The NLRB only applies to private sector employees, but under the famous case of Weingarten, it held that union members have a right to be represented by their union when they're subject to an investigation that could lead to discipline. The courts and PERB in California have extended those same Weingarten rights to public employees in California. For example, under the MMBA, 3502 is the right to be represented, and 3503 is the right for a union to represent its members. And PERB has held that that provides a similar and in some ways more expansive right than these procedural rights in 3303 of the Peace Officers' Bill of Rights. So looking at these Weingarten rights, some of the concerns, that an officer can delay an investigation are simply not true. The officer does not have an ability to do that. The courts have said that the officer can be given a reasonable amount of time, which is days, not weeks, to obtain a representative. The employer controls the employee. It's different than a civil case because it's your employee. So you can order them to come in on duty at any time and provide a statement. And in fact, on cases of serious misconduct, that's done almost immediately or within days of the accusations coming forward. The firefighters have a Bill of Rights. It's essentially identical in this regard. The Weingarten right is broader because the Bill of Rights pertains to when the employer thinks the questioning could lead to discipline. The Weingarten right is when the employee thinks it could lead to discipline, which essentially, under the labor laws, the employee can say, I want a representative in almost any circumstance. And then PERB has taken it even further, and they've expressly held that the rights in California, as in my opinion they should be, are broader and more expansive than the federal minimum standards. And so unions have a right to represent their members and basically be present anytime that they're being just having a discussion about performance issues, fitness for duty evaluations, medical issues, drug testing, even counseling on performance. So I wanted to also talk about the notice rights. And so I want to be clear that everybody understands the notice is very, very minimal. It's basically enough of a factual summary, like I'm talking a couple of sentences, so that the officer knows what the interrogation is going to be about. That's to the benefit of everybody. If you call an officer in and say they received the agency received a complaint about something that happened 6 months earlier on being rude and discourteous on a traffic stop, they're going to have no idea, and the responses are going to be, I don't remember, unless the officer is told in advance and has a chance to think about it so that they can recall that event and then testify truthfully about it. But there's a Supreme Court case that says you're not entitled to a copy of the entire investigation. They're not even entitled to a copy of the complaint against them. It's just basic information, like you're accused of excessive force during this call for service that you had on such and such a date, so they know what it's going to be about. Weingarten and the Ninth Circuit have actually gone even further than just nature of the allegations, and they've said that as a union representative, you have the right to secure information regarding the subject matter and a pre-interview conference with a union representative. It's not much different, but they make clear that it's enough so that the accused employee can talk to their union representative and they know what the subject matter is going to be and they can prepare. There is a case down there at the bottom, Ellens versus Sierra Madre, and in this case, the court was looking at the rights under POBR, and they said that they are parallel to specifically that Pacific Telephone case and to other union rights. Importantly, in that case, the officer and his representative complained that they weren't given enough advance notice, and the court said it was sufficient under the Bill of Rights that when the officer and his representative arrived, that they were given time to talk and then give the statement that same day. And I think it really drives home the point that the Bill of Rights in California does not delay or impede the ability to conduct a fair and thorough investigation. Chief Rambo had mentioned the right against self-incrimination, and I wanted to just touch on this too and remind everybody this is a constitutional right. There's a balance between a Fifth Amendment right against self-incrimination and the important public interest in knowing what its officers are doing. Officers are held to a higher standard than other employees. They're subject to 832 et sec of the Penal Code, which mandates a procedure for receiving complaints and investigating complaints and even internal complaints. And my clients understand that, particularly in these times, these are important procedures to maintain public confidence, but you have to balance the right against self-incrimination. And this is only in the disciplinary sphere, because if you're looking at a normal criminal defendant, they would just invoke their right to remain silent and say nothing. And so that balance is Lybarger, where the officer is compelled to give a statement, and that statement can only be used for purposes of discipline up to termination. There's a number of exceptions where they can actually still come into court. The firefighters have a much stronger protection. They can only be interrogated regarding matters that have a criminal connotation if there's a written grant of immunity. Other public employees are essentially subject to the same Lybarger rule. There was a case called Spielbauer that clarified that you don't have to be the prosecuting agency or a law enforcement agency in order to compel an employee to give a statement, even if it involves potential criminal matter. So the point here is that officers can't just invoke the right to remain silent and refuse to give a statement regarding allegations of excessive force or sexual assault or any of those serious matters. When we turn to the disciplinary appeal hearing, the Bill of Rights does very little, actually. The right to appeal discipline for public employees in California goes all the way back to the Skelly decision, and it's a matter of constitutional rights. Employees have a Fifth Amendment right, public employees, I should say, have a Fifth Amendment right to their continued employment, and they have a 14th Amendment due process right before that can be deprived. And so I think everybody remembers Skelly. It has two parts. Give a quick refresher on it. The first is pre-deprivation, meaning before the discipline is imposed, the employee has a right to a copy of the investigation and to respond, not in an evidentiary, but just to meet and respond and explain. If the discipline is imposed, they have a right to an evidentiary hearing appealing that. These rights are not in POBR, and they are existing regardless of POBR. All that the Bill of Rights says is that no punitive action can be imposed without the opportunity for an administrative appeal. It's just a restatement of existing law. It goes on to say that the local agency shall set the rules and the procedures for appeal. That's your civil service system. That also exists, and this is just a restatement of the existing law. The Bill of Rights provides a right of access to adverse comments and to personnel files that can be used to discipline expressly. There are other statutes that apply to non-sworn employees in California, and this is a pretty standard right, aside from a right to work state that any employee, whether private or public in California, has. The Firefighter Bill of Rights is essentially the same, with the exception that it actually specifies what the appeal procedures are, and they're much more robust. It mandates either the Administrative Procedures Act or binding arbitration. With respect to peace officers, it runs the gamut. I would say the majority is a civil service board that's vested with hearing these appeals. They're citizens appointed by elected officials. Some jurisdictions have arbitration, but that's the minority. Some have city manager or city council review of these types of decisions. But there is, as the prior speaker mentioned, a wide availability for civilian oversight, and that does in fact exist within the appeal process itself, as well as in many jurisdictions, there are civilian review boards and other measures. And I should also point out that as part of this moment and reflecting on police reform, my clients have been active participants working with the stakeholders and working with the leadership to enact statewide use of force standards, to reform use of force policies, to increase transparency, and also establish a process for decertification of officers who commit serious misconduct while still affording them due process rights. I do want to talk about the statute of limitations. I understand from the prior speaker that there was some concern. There's some important things to remember here. The statute runs from the discovery of a person authorized to initiate an investigation. Jumping my slides here a little bit, but there is a 3-year statute of limitations that generally applies to public employees in California. But that 3-year statute of limitation, I think it's right here, it runs from the date of occurrence. So if nobody finds out about some misconduct and 3 years elapses, then it's time barred. That doesn't apply to peace officers. It's a year from when somebody who is authorized to start an internal affairs investigation finds out about it. I can tell you, doing this 22 years, it's never going to be the case that a serious misconduct allegation time bars out. Where it comes into play is really minor stuff that is like showing up. Actually, the only one that I've experienced in my career was traffic collision that would have resulted in a letter of reprimand or a day off at the most. And the agency waited a year to do it, and then they blew the day, which they really shouldn't have been waiting a year. But beyond that, there are a ton of exceptions that are going to apply to almost every serious misconduct allegation, and actually most allegations of misconduct against an officer. If there's a criminal prosecution of the officer, the time is told. If there's a criminal prosecution of the complainant, the time is told. If there's multi-jurisdictions, meaning, you know, a city police officer and a deputy sheriff, it's told. If there's more than one officer involved, it's told. If the officer is unavailable, if he's on work comp, if he's on vacation in another country, the time limit's told. It's told for allegations of work comp fraud, and it's also told where there's civil litigation and the officer is a defendant. And beyond all of that, there's an ability of the agency to reopen the investigation if there's new evidence. The Firefighter Bill of Rights has a similar statute. There's also a civilian statute for civilian police employees in the MMBA. That's the same. And then you also have even some shorter time limits in other public employee and private sector employee collective bargaining agreements. I would submit to the committee that there is a very strong public interest in maintaining time limitations on discipline. The entire point of discipline is to change behavior and correct behavior. So you have to put an employee on notice that what they're doing is deficient and then correct it. Now, again, if we're talking about something like a use of force or an allegation of sexual assault, I can tell you from experience, in those cases, the officer is put on administrative leave and they're interviewed within a week or so of that happening. Now, to be fair, the agency is going to want to interview the other witnesses first, but there's no way that they're going to leave an officer working for a year or more than a year without conducting the investigation. And if they were so inclined, it would be in the public's interest to put a time limitation on that to force them to conduct a timely investigation. And if that officer committed serious misconduct, remove them from the force. If they didn't, then clear them and put them back to work, so you're not paying somebody not to work or just leaving it hanging over their head. Where the time limitations typically would come into play is on minor issues like, for example, a detective who is not writing very good reports or conducting thorough investigations. And the public interest would strongly, in my view, be in favor of timely correcting that rather than allowing them to continue to conduct deficient investigations for a year before you take action, or more than a year before you take action. It does not impede the disciplinary actions or the completion of the investigation. As I mentioned, agencies prioritize the more serious misconduct. They can order an officer to come in and provide a statement at any time. The officer cannot delay that beyond maybe a few days at most in order to obtain a representative. And many times in my practice, the officer's been ordered to come in and give a statement immediately on serious misconduct, on critical incidents, all of those things, and their union facilitates getting an attorney or getting a representative for them immediately. And I also want to point out another risk of not having a time limit, and this one maybe hits a little close to home. I personally represented Michael Ziegler, who was the president of the Sacramento County Law Enforcement Managers Association, the time that Assemblymember Cooper was running for sheriff back in around 2010 or so. And Mr. Ziegler was subject to an internal affairs investigation for bringing disrepute on the Sacramento Sheriff's Department by filing a grievance and investigating a grievance. And I believe that the intent of that was to place him on a gag order indefinitely, and we were able to go to court and get that lifted and have his name cleared. But there is a risk of misuse and abuse if there's not a time limit, so that these allegations are resolved one way or the other. And just in closing, want to note to the committee that virtually all states have statutes establishing similar type procedures for public employees. They're not always called a Bill of Rights. They're contained in other statutes, in case law, and other names. But the protections in California's Bill of Rights are at the lower end of the scale, as the prior speaker mentioned. I agree with that. They're basic union rights more than anything else. There are 14 or I think actually that number has increased to 17 states that have express Bill of Rights. I do want to point out with Illinois and Maryland, there has been some misleading or confusing reporting on what was actually done on the so-called repealing the Bill of Rights. Both states still have a Bill of Rights for officers. There were amendments done. And if you dig deeper and look at what was actually done, they weren't really changes to the Bill of Rights. They were enactions or reforms, enaction of reforms very similar to what we did in California with respect to AB 392, which I was involved in, SB 230, which I was involved in, and 1492 and SB 1492 and 16, which dealt with transparency. And so Illinois, what they did is they enacted use of force changes, they enacted body camera mandates, and they strengthened decertification procedures similar to what we did in California with SB 2. Maryland, very similar. They increased civil and criminal liability. They mandated disclosure of disciplinary records. They implemented statewide use of force standards and a requirement to have body cameras by July of 2025. New York never had an express Bill of Rights, but they have similar rights through collective bargaining and other labor statutes. And the big change with reform in New York was the disclosure of disciplinary records similar to what we did in California. And just in closing, if the committee and the legislature is looking at making changes, what I would strongly recommend is codifying these basic union rights. This is a union state for all public employees. I know that there was legislation back in 2012 that considered doing that. I'm not sure why it didn't pass. I think it would make a lot of sense. It would make it a lot easier for public employees to understand their rights instead of having to find these various rights through PERB decisions and case law to put them right into our labor statutes and show the rest of the country how to take care of public employees.
Mr. Mastagni, thank you very, very much for going in depth. We really appreciate your presentation. Allowed you to go over your time allotted because I think the information you provided was absolutely necessary. So again, please stand by. We're going to have additional questions. I've taken some notes. I'm sure my colleagues has also taken some notes that we want to ask you. You raised a number of particular questions for us in our mind, so we want to be able to get to you. So please stand by. If the time will allow, if it doesn't allow, please let us know, and then we'll try to make some adjustments in our agenda. We also are, again, happy to have on the line Mr. Mark Harris, civil rights attorney with the Ben Crump Law, with us virtually. Mr. Harris, are you with us now?
Absolutely. How are you, Mr. Chairman?
I am doing extremely well. Thank you so very, very much for joining us and providing your testimony. You've heard those who have already testified and made presentations, and so we want to yield the floor to you at this particular point in time to give your presentation as well. So please introduce yourself and commence with your presentation.
I appreciate it. Mr. Chairman and members of the Select Committee, it's a real honor for me to be here. Let me first thank you for granting me the opportunity to join you. This is a very important topic, of course, for the entire state of California. The subtext of today's exploration for this panel is supposed to be investigating misconduct in practice, investigating misconduct in practice. And that's where my comments and remarks are going to be focused. We've heard some great speakers so far talk about the challenges associated with the Peace Officers Bill of Rights. Not every element of it is wrong as far as I'm concerned. That's my personal opinion as an attorney here in Sacramento. Not every aspect of it is right. The previous speakers did a great job of pointing out some of the protections for law enforcement that many people believe are appropriate. So I would just commend them for that. I want to bring greetings from my law partner, attorney Ben Crump. We're headquartered in Tallahassee, Florida. I'm the managing attorney here in Sacramento. I split my time between here and the Central Valley, specifically the city of Merced. Our law firm has a long history in representing the voiceless, in representing those who many times are forgotten, disenfranchised, or disrespected. We represent the families, of course, of Trayvon Martin and George Floyd, of Breonna Taylor and Ahmaud Arbery. And here in Sacramento, we represented the family of Stephon Clark. I still count his brother Stevante as both a friend and someone who I connect with on many aspects of social justice and civil rights. So we've had an amazing run over these past several years of really exploring the issues at the core of this process. I really want to just, if I can, ask you and your colleagues to go with me to just an aspect of this. All of the things that the previous speakers have talked about in some manner or another are true, both factually and in practice. But, you know, I'm old school and I'm from South Central LA, Mr. Chairman. And, you know, some of the things that were shared with me as a youngster growing up in South Central, I still use and embrace. And one of them was the premise that junk in results in junk out. What we should really be focusing on, in my opinion, is the part of this puzzle that rarely gets the sufficient level of attention. That's the intake process. What happens when a person has a legitimate complaint against a law enforcement official or officials? Where does that go? What is the actual process associated with that in real terms? Let me share with you and your colleagues, if I may, just a little bit of my 40 years of experience in this space. In the very building in which you sit, I was the chief of staff to the then chairman of the Assembly Judiciary Committee, the Honorable Elihu M. Harris. I served under both Governor Gray Davis as the Undersecretary of Business, Transportation, and Housing. I had oversight at the time. Our department had oversight over the California Highway Patrol. I also served in that building as an appointee of then Governor Jerry Brown, Edmund G. Brown Jr., and I was an appointee to his Fair Employment and Housing Council. So I've had an extensive history relative to state government policy. On a local level, I have served as a police review commissioner or board member, depending on the jurisdiction, in Berkeley, California, in Oakland, California. I was the chair of the Civil Service Board in Oakland, California, which, as your previous speaker just acknowledged, has the responsibility for really the actual discipline that an officer may face. The police review process is really two steps. It's the advisory committee, some of which have subpoena power, some of which you don't. And then they make a recommendation, of course, to a civil service board, which then determines whether or not there should be discipline that the officer faces. So I served in both of those roles, and I've also served in my university, the University of California, Merced, on the Police Advisory Commission there. So I've looked at this not only as a lawyer on behalf of clients, but as a policymaker, as a person who really has tried at a local government level to get a handle on a number of these different issues. I will say that one of your colleagues, your Senate colleague, who represents Vallejo, had a town hall meeting a few weeks ago, had Senator Bradford and others explaining SB 2. I thought it was really, really well done. One of the participants was the dean of the UC Davis Martin Luther King Jr. School of Law, Kevin Johnson. And Kevin Johnson said something that I think is really on point here with everything we've been talking about. These issues associated with the Police Officers Bill of Rights and giving if you can, some clarity and transparency to the process of disciplining officers. They're not going to be solved by lawyers and judges. If they're to be solved, they're to be solved by policymakers. And that's why what you and the Select Committee are doing is so very, very important. Many people talk about how to make this better. I want to just kind of take a step-by-step approach to some of this. And at the end of my remarks, I'm going to make three hopefully tangible and credible recommendations. So in 2016 here in Sacramento, I was frustrated, as many of us were, over the murder, as we saw it, the killing, we felt unjustified, of an intellectually disabled gentleman in the Del Paso Heights section of Sacramento. His name is Joseph Mann. We've heard about Stephon Clark. The whole world knows Stephon Clark now. The whole world knows George Floyd's name. Very few people knew Mr. Mann's name. His circumstance was he was babbling incoherently in that neighborhood. Law enforcement showed up at the report of a possible penknife in the hand of Mr. Mann. And in fewer than 30 seconds, the officers on the scene tried to ram him with their car, leapt from their vehicle, and in a fusillade of bullets took his life. He was unarmed, as it turned out. That in 2016 made me really think about the role that I'm playing in this process. And I said, you know, these problems really are not going to be fixed by lawyers, with all due respect to the lawyers who are here assembled. They're going to be fixed, hopefully, by the people. So what I did, along with two colleagues, is formed a new group here in Sacramento that goes by the acronym LEAD, L-E-A-D. And LEAD stands for Law Enforcement Accountability Directive. We believe that with LEAD, what we could do is set up an NGO that would give a voice to the voiceless. And one of the first accomplishments of LEAD was to make sure that in the city of Sacramento, the policy regarding cameras would change, both dash cameras and body cameras. This was before the legislature took its action through the Weber legislation. We were among the first jurisdictions in the state to have a requirement that audio and video transmissions, if available, we're not saying that every situation had them available at the time. There are all kinds of reasons why law enforcement will legitimately disengage their cameras. But if available, we got a local ordinance passed here that required they be turned over within 30 days. That was humongous. And that came as a result of so many complaints that came forward to our office and others of people who said they were mistreated by police, but there was no audio or video corroborating evidence. So that then, of course, on a state level got lifted to where we have it now. And I'm very happy to see that. Many of those who are from my community, and I live in South Sacramento, the dominant ethnicity, if you will, is multi-ethnic. We have API, we have Latino, we have African-American, we have Caucasians, we have members of the Hmong community. We have people from all over the world and all over this country who have settled in this part of Sacramento. And one of the things that makes it, in my opinion, a very important part of our city is the diversity that we have, is the both economic diversity, the ethnic diversity, et cetera. As I have talked to the various people that I interact with on a regular basis, just right here in Sacramento, one of the things that drives a number of people to distraction is that they feel they have no recourse if they've been subject to some level of inappropriate police conduct. Let me tell you specifically what I mean. In my written testimony, I gave examples, pretty lengthy in some cases, of an officer using something other than deadly force inappropriately, and the process associated with transparency and accountability for those actions. I quoted my law school dean. I'm a graduate of the University of California, Berkeley School of Law, and Erwin Chemerinsky has written a brilliant book really looking at these issues that we've been discussing today. And in one segment, what he does is explores the concept that not every aspect of police inappropriate behavior is with the use of deadly force. He talks specifically about violations of the Fourth Amendment search and seizure requirements and the fruit of the poisonous tree. And without going into that whole detail, that treatment has been relegated to my remarks, which have been presented to your staff. I want to talk about an aspect of that, though, and then I want to move towards the specific recommendations that I have. In our circumstance, and I'm sure the other attorneys assembled could attest to this, we have certain thresholds of where we can accept cases. In our intake process, one of the things, of course, we have to do is make sure there are legitimate claims, that there's a legal right for whatever is the claimed wrong of the person who's come to our office, and quite honestly, that there is sufficiently a level of damages that could be available to the complainant if, in fact, we proceed with litigation. Let's take litigation off the table, though. What about those complaints that don't meet that threshold? I've had numerous cases, including a woman who came in and said while she was in police custody, her breast and her vagina were fondled by law enforcement. She didn't have video corroborating evidence of that. She didn't have witnesses who could corroborate her claims, but she made a very legitimate set of claims, in my opinion, that this had in fact occurred. Because we could not locate any video corroborating evidence or corroborating witnesses, we were unable to take that case as a litigation matter. But what we did suggest she do, and she followed up, was to file a complaint. There's the litigation path. We all know that to deal with the Torts Act, you've got to file within a certain amount of time within the jurisdiction in which you have the complaint. That's pre-litigation. But what about all those people who never make it into the pre-litigation space, who legitimately have complaints about how they were treated by law enforcement in their jurisdiction? What about them? Those are the folks that I really hope your committee will spend some time taking a look at. And we have some very specific suggestions relative to what should change in that process. We just heard a statement about statute of limitations. One of the things that Attorney Mastagni talked about was the statute of limitations and the tolling of the statute of limitations. It's pretty clear in California that if you're going to bring a complaint against an officer, you only have a certain amount of time to do it. And that typically is 1 year or less. It's not that 3-year process. So if we have a person who's claiming abuse and they weren't able to get their complaint, if you will, gathered together in the time period allowed, there goes that complaint. And all the things that were part of what Senator Bradford and the rest of you hope to accomplish in SB 2, getting rid of bad cops who move from jurisdiction to jurisdiction, this doesn't become part of that record if a person isn't in a position to bring forward their claim. So we hope that there are some things that you will agree should happen throughout our state. First and foremost, there ought to be a template in place. We know it's a local jurisdictional issue to set up to make the decision whether to have or not have police advisory, police oversight advisory board. Some, in terms of the city of Oakland, have gone as far as to give their police advisory apparatus subpoena power. The people who come and testify are testifying under oath. I like that model. But in Sacramento, we have 2 different systems just within the city and county of Sacramento. We have a system within the city of Sacramento that is completely separate from the system that is in the county of Sacramento when one is bringing a complaint against the sheriff's department. That needs to end. There has to be some consistency if a person moves from jurisdiction to jurisdiction. In the case of Sacramento, they can move from the city to the county, and they have a whole different intake system to deal with in terms of lodging a complaint against a police officer. We hope there'll be some changes that you will support in that regard. Another part of this is once the complaint is lodged, where does it go? Well, it goes to internal affairs. Many of my clients believe that an internal affairs person is no more than a cop in a suit. I mean, they don't feel comfortable trusting that the system will in fact give credible investigation to their claim. We hope that there is something that could be done to give people a heck of a lot more comfort, to encourage them to come forward in terms of the process associated with the intake of complaints against officer or department misbehavior. Third, one of the things that is really near and dear to me is the number of clients I've had who said, I'm not going forward with any complaint for the following reasons. Number 1, I'm on parole. Number 2, I'm on probation. Number 3, I got outstanding warrants. Or number 4, I'm in this country without documentation, and I don't want to trigger a deportation process by making a complaint against law enforcement. we need to be aware that these are real and that the very people who are most victimized and disenfranchised are the people who have a little, if you will, lint on them. They are not coming forward because of all these other challenges. And I hope there's a way that reasonable people can come up with a change to the system and process that will encourage the very victims of police inappropriate behavior to come forward. Finally, the fact that you file a complaint against an officer typically in one of 2 or 3 places: City Hall, the police department. That one doesn't make a lot of sense to me. That's like inviting the chicken into the fox den. That one doesn't make a lot of sense. Or the third is in some broader administrative building associated with city government. In Sacramento, for example, it's in City Hall, but it's not in the police department, nor is it in the mayor and city council's office. It's in an administrative location that I assume people feel will be more welcoming to the people who are filing complaints. We, I hope, could figure out a way to bring to the people what the people need. And by that, what I mean is we should have NGOs and nonprofits that can intake complaints against police departments. It's going from there to whatever the next step is anyhow. So the people who would say, well, that doesn't make sense because you have to make sure that it's a secure environment and one in which you don't have a manipulation of the process. All we're talking about is an intake of the complaint. In most jurisdictions, you can do that now virtually via the internet. So to have existing, credible NGOs that are within our communities be the place where people can bring a legitimate complaint against law enforcement, we think makes a heck of a lot of sense, and we would really like to see that happen at some point going forward from this point. So those are the big concerns. I have an extensive 10 pages of testimony that I have offered to the committee. I'm not going to bore you with all the different aspects. I will say that the efforts to try to deal with the challenges presented by qualified immunity in our state have been on the right path. Unfortunately, we weren't able to go across the finish line with that through SB 2. I know Senator Bradford and others have talked about going back and taking another stab at doing what is right relative to qualified immunity. The fact that 99.98% of the judgments that have been paid out by government. I tell people one of the problems with this whole system is at the end of the day, if the officer is found to have done something inappropriate, it's not the officer who writes the check. Of course, it's the jurisdiction who employed the officer. That has to change. So with that said, I want to thank you for giving me an opportunity to join you, and I'm more than happy to answer any questions.
Thank you very much, Mr. Harris, and appreciate your presentation. Again, we'll just ask if you can please stand by. We have a few more panelists we want to get to and hear from, and then we'll be opening up for my colleagues here to ask you pointed questions that you have articulated in your presentation. But again, thank you very, very much for giving us your point of view. Next up, we want to bring up Mr. Godfrey Sheldon, who is a partner and the chair of the Public Safety Group at Liberty, Cassidy, and Whitmore, who represents police chiefs in cities and departments who will be joining us virtually. So, Mr. Sheldon, are you with us?
Yes, I am. Can you hear me?
Thank you so very much. We asked you introduce yourselves, give us a little history about yourself, and then move into your presentation. We've been giving very liberty in terms of the time because this subject certainly warrants additional time and articulation around POBAR. So please commence right now. Thank you.
Okay. Thank you, Chairman. Appreciate it. So first, I'd like to start by introducing myself. As you mentioned, my name is Jeffrey Sheldon. I'm a partner with Liebert Cassidy Whitmore. We are a law firm that specializes in public sector employment law. We represent approximately 75% of the public agencies across the state of California, and we are a California-only law firm. I personally am the chair of our public safety practice group, which means I work pretty much exclusively with law enforcement agencies and fire departments in connection with all of their labor and employment issues, from collective bargaining getting to those memoranda of understanding or collective bargaining agreements, to the disciplinary system. A heavy dose of my practice is involved there, to litigation involving POBR rights, and the disciplinary process in general. And I've litigated all the way, from the administrative hearings themselves, the appeal hearings that we've been talking about. I provide advice and counsel to chiefs of police and sheriffs in the investigatory process to make sure that it is done correctly and in compliance with the law. And then on occasion where these matters go to the courts, I litigate those there as well. And so I've seen these things from that perspective. I'd also point out that Mr. Mastagni, one of your prior speakers, he and I are in the same lane, if you will, except he's on one side and I'm on the other. He represents the unions, I'm representing management. And so just be clear that that's the perspective that I come from. I try to help the chiefs, if you will, do the right thing, investigate these complaints that Mr. Harris just mentioned when they do come in. And I do represent departments big and small. And the challenges in dealing with these issues do somewhat differ depending on the size of the agency. I work for very large sheriff's departments to very small police departments, with 10 plus police officers in their entire agency. And because of the discrepancy in the size of agencies, something I think the committee may want to keep in mind is one size fits all is sometimes difficult because of the size of the agencies that we have here in California. So with that, the question posed is, how does the POBR work in practice? The POBR, it's found in the government code section 3300 through 3313. It does a lot of things, not just regulate the disciplinary process. I think it's important to appreciate that. 3302, for example, regulates political activity on duty. 3303 of the government code is one of the more important provisions in my estimation, and that's the one that regulates how administrative interrogations are conducted. 33, it also, for example, 3303 regulates the timing and length of interviews or interrogations with officers. It regulates who can ask questions. It mandates advanced notice of what the officer will be questioned about. It has provisions regarding pre-interrogation discovery, so information that must be provided to the officer prior to being questioned. There are provisions on that. As Mr. Mastagni mentioned, there are requirements for Miranda warnings and use immunity when the matter being investigated has both criminal and administrative implications. And then there's obviously the right for the officer to have a representative of his or her choice present during the investigatory interview. Section 3304 is another significant provision of the POBR. That one mandates an administrative appeal for punitive action. One of the things I think that differentiates the POBR and the FBOR from laws that implicate other types of public employees is the level of discipline or a peace officer or a firefighter where they can appeal it is much lower. Written reprimands are covered, for example, under 3304. And in practice, what that means is if an officer gets a written reprimand for a violation of policy, which in all these agencies, there are concepts of what is called progressive discipline. You start with lower level discipline, unless it's a very, very serious act of misconduct, and then you progressively make it more severe. Well, with written reprimands, those can be appealed. Sometimes those appeal hearings can take multiple days. And because of that, there's somewhat of a disincentive for a supervisor to issue a written reprimand to correct behavior. And that's just a fact of life, if you will, given the way the POBR is written at present. 3304 also has what's been talked about today, which I think is a very significant and important provision, which is that 1-year statute of limitations period. That is, in my view, it's an area that I think if the committee is going to address something, that is something that you do want to strongly take a look at. While I agree with Mr. Mustagni, there are provisions in there for tolling. I don't agree that it's as easy as he makes it seem to complete an investigation in 1 year in all cases. There are certainly situations that I've helped our clients with where it is difficult to get witnesses in, particularly non-civilian witnesses who maybe are afraid to come forward or are unavailable for one reason or the other, to get that investigation completed, reviewed, evaluated, and then the notice of discipline to go out in a timely manner in a 1 year period is not as easy as one would think in all occasions. And missing it by a single day results in no discipline being imposed against the officer at all. But that is a provision of 3304. There are other sections of the POBR, 3305, 3306, and 3306.5, which regulate what can go into a police officer's personnel file. And these provisions also allow an officer to review the file, request that material be removed from the file, and give them the right to submit rebuttal material to, a poor evaluation, a disciplinary action, or other adverse comments that might go into an officer's personnel file. Section 3305.5 is another provision of POBR that prohibits a department from terminating or disciplining an officer because that individual has been placed on a prosecutor's Brady list. And there are implications to that. A Brady list is something that DA's offices keep concerning officers who have a history of dishonesty and other acts of misconduct that may jeopardize their ability to prosecute a case. And they have to turn that information over to criminal defense attorneys. This provision, which was added more recently, says, department, sorry, you cannot discipline this officer who in many ways is no longer used to you because they cannot be a good witness. You cannot discipline them because the DA has deemed them untrustworthy as a witness. 3307 of the Act prohibits lie detector tests. Mr. Mustagni mentioned that. 3307.5 regulates the distribution of photographs of officers. 3308 regulates inquiries into officer finances, except in some exceptions with respect to special assignments like vice and undercover assignments. 3309 regulates searches of officers' lockers. 3309.5 is another significant provision. It's what I call the remedies provision for violations of the POBR. And that provision allows specifies what the remedies are when there is a violation. And the most significant one is injunctive relief, which as a practical matter means suppression of evidence or the overturning of discipline when there's been a misstep by an internal affairs investigator, or there is that minor violation of the Act, for example, not giving them enough notice of what they're going to be interrogated about. Stuff like that, that can overturn or suppress evidence which can keep an officer on the job when perhaps they shouldn't be. So those are the significant provisions of the POBR. That's what it does in practice, I think. One thing to also remember, and some of the other speakers have mentioned this already, but there are other laws that implicate the disciplinary process that are outside of the actual POBR that are important to, I think, keep on your radar as a committee. One is the Myers-Milius-Brown Act. That is the collective bargaining law that applies to all unions in California. It's been mentioned here that unions do have the right to negotiate a whole host of things, from salary, obviously, but also to policies and procedures, including disciplinary procedures. There's MOUs that have discipline guidelines and matrices that say, you know, an officer can only be penalized such and such for this type of misconduct. And so that's something that you just need to be aware of, that if there are changes to the act, those can be addressed through the collective bargaining process theoretically, and there are things that I think the committee could do to prevent that if it so chose. The other law that is implicated here is the PICHIS statutes, Penal Code Section 832.7 and the Evidence Code Section 1043 et sec. Those concern access to peace officer personnel records by the public and other individuals, third parties. Those impact the disciplinary process in a significant way. And to the extent that you're going to take a look at any sort of changes to the POBAR, I would suggest you look at all three of them together because they all are interrelated in some manner. One of the other questions, as I understand it, that the committee had interest in is how internal affairs investigations are conducted with POBAR on a kind of a day-to-day basis. And I'll just go through the process with you so you understand, because generally speaking, I am, and people in my firm are on the front line, and that we are contacted by a police department when a complaint comes in. And we often get questions about what to do and how to go through the investigatory process to make sure that it's done in a legally compliant and fair manner to the officer and also to the complainant. Because I will say the internal affairs professionals that we work with, they are professional. They do, for the most, there's always bad apples in every bunch, and I will really acknowledge that. But for the most part, they want to do the right thing. They want to police their profession. They want to do it in a fair manner and a legally compliant manner. But the process generally is the complaint comes in, and actually sometimes the complaint is not what you would think of as a complaint. It's not a written document that says, I believe my rights were violated or this officer did something wrong. One of the issues, and it really implicates the statute of limitations that we were talking about earlier, is that what can trigger the statute of limitations running is not just a written complaint. It's any sort of information by someone authorized to initiate an investigation that would put that person on notice that the officer might have engaged in misconduct. There's a case that kind of explains the nuances of this. That's Pedro versus City of Los Angeles, that I think the committee might want to take a look at, and just to see how nuanced this can be, because it's not what you would think of. We have a complaint coming in, there should be an internal affairs investigation open on this day. There are pre-complaint information that can come into a department. You might not even know who the officer is, what their name is. That can trigger the statute of limitations, and if again the department misses it by one day, discipline cannot be imposed against that officer. But the next step is to open the formal internal affairs investigation. There will be an investigator assigned. Some departments, larger departments in particular, have internal affairs units within their organization. Many other departments contract that out because they do not have the expertise, they do not have the staffing to be able to do it. And there are a host of private sector companies, investigative companies that are staffed with lawyers, some ex-law enforcement who conduct these investigations, and they are objective and neutral in my experience. That's part of their business model. If they are not objective and neutral, they're not going to get repeat business because what they're being hired for is that objectivity, that neutrality. But the investigator comes in, they collect relevant documents, they will interview witnesses. Usually the complainant is the first individual interviewed. Other individuals identified or interviewed, and ultimately the subject of the investigation, the accused officer or officers, are interviewed as well. Prior to being interviewed, the subjects, you have to treat them a little bit differently. They have to be notified of what they're going to be questioned about. And if that is not done properly, that is another basis for a POBAR violation where evidence can be suppressed or the discipline overturned. As an example, I had a client recently who conducted an investigation of a domestic violence incident involving an officer. And the notice that the department prepared mentioned the domestic violence incident. There was also, though, an allegation that the officer had used drugs and had taken his patrol car outside of city limits without authorization to do so. And the investigator asked questions about that, but he neglected to put it into the notification that went to the officer. The hearing officer in the case suppressed all of the evidence about the use of drugs, the car being driven outside of city limits for personal reasons. And, that is a fact of life because the investigator made a mistake in that scenario. The complainant will be, the accused employee will be represented by an attorney. Usually it can be a non-attorney representative. There are some difficulties sometimes in getting a date that can slow down the process, but I agree with Mr. Mastagni. Given the case law as it stands now, there's a really short leash, and the department can order the officer in relatively quickly. One of the issues, though, with the representative issue is, at least in my experience, the same attorney is often representing the accused officer and also representing other officers involved in the investigation. And with that comes the possibility of the sharing of information between witnesses and the subject. And at present, that's permitted under the Act. After the investigation is completed, which means there will be a report drafted for typically the chief of police or the executives within the law enforcement agency. That is reviewed, analyzed, and if corrective action is to be taken, if there are sustained findings against the officer, there will be a notice of intent to discipline. And that's where the Skelly process that Mr. Mastagni mentioned earlier comes into play. There are pre-discipline due process rights that come from the Fifth Amendment, and then there are post-discipline due process rights as well, which is a hearing before a neutral hearing officer. And that's a right that exists for all public employees, so it really, it doesn't need to be stated necessarily in the POBR because it applies anyway. It's a matter of constitutional law, but that is the process. There will be a notice of intent, a Skelly meeting, and then an appeal process. And some of these appeal hearings, some can be one day, but depending on the allegations, some of them can be, I've had cases where they're 20 plus days of hearings about whether the officer engaged in misconduct or not. And I would say the 20-day one is unusual. Mostly they're 3, 4, 5 days, in my experience anyway, but it's a time-consuming, and it can be costly to the agency. They do have to pay for representation, both at the investigation stage and prosecuting the appeal, because ultimately the employer, the employing agency, the office of the chief, has the burden of proof to establish that the officer engaged in misconduct, number one, and number two, that the level of discipline was appropriate under the circumstances. As far as who hears the appeal, it varies from agency to agency. Some involve civil service commissions or personnel boards that are appointed by elected officials. In my experience, though, most of the hearings that we are involved in, they're heard by private arbitrators, each of which has their own views on what discipline should be or should not be, the level of discipline. Everybody has their different viewpoints. Some are considered pro-employee, some are considered pro-management. But they will make the decision in many, many cases, an arbitrator, and will second guess, if you will, the chief of police. And from there, the loser can go to court. They can file a petition for administrative mandamus under Code of Civil Procedure 1094.5, and that can go up to the appellate courts all the way to the Supreme Court. One last point, I believe the panel was, one of the questions that I received anyway was, how does the POBR align or not align with the rights of other public servants in California when under investigation? The differences, in my view, are that the prospects of evidence being suppressed due to a violation of the POBR simply just don't exist with other types of employees. Whether there was a violation of the POBR, when that happens, as it stands now, generally speaking, the evidence is suppressed, and sometimes the discipline is overturned, even if it is a mistake and a non-intentional violation of the act. That doesn't apply. That concept doesn't apply to other types of employees, generally speaking. The statute of limitations that we've talked about, it's 1 year. While I agree, most of these investigations can and should, and quite frankly, the department has an incentive to complete in 1 year, that's not always the case, and there's a variety of different reasons for it. And the inability to do that can lead to some draconian results. Other types of employees do not have the right to notice of what they're going to be interrogated about prior to the investigation, at least not the extent, I believe, as officers do under POBAR or firefighters do under FOBAR. There's no right to in pre-interrogation discovery, generally speaking, for other types of employee like there is for officers. There's a case, Santa Ana Police Officers Association versus City of Santa Ana, which has held that if an officer is a subject officer is interrogated twice. So say the investigator needs to go back to the officer and ask some follow-up questions. That court said that, and it's been interpreted this way, but at least by the union letters that we get, that the officer is entitled to everything in the investigator's possession. What other witnesses have said, transcripts of their interviews, all the documents collected, all of that stuff needs to be provided to the subject officer if there is going to be a second interview of that officer. And that is, in many ways, not a sound investigatory practice, providing all that information, because some officers will take that information and tailor their testimony accordingly. I mentioned this, the level at which an administrative appeal is permitted for an employee is lower for police officers and for firefighters than other types of public employees. They can appeal written reprimands, which in my view sometimes is a disincentive to issue that lower level discipline, because it can trigger an expensive and time consuming process. And that's the first part of the progressive discipline process. And so I don't think disincentivizing that is necessary great public policy. And then there are provisions, as I mentioned, in the POBAR about peace officer personnel files and what can go into them, and the officer's right to have information removed from them. That is, as a matter of state law, not applicable to other types of public employees, generally speaking. It is a matter of collective bargaining, and there are agencies that do agree to provisions like that, but it's not part of a state act, if you will. So with that, I'd be happy to answer any questions that the committee has, and I thank you for your time and inviting me to participate.
Mr. Sheldon, thank you very, very much. We appreciate your testimony, appreciate the information you brought out before us and representing the group of chiefs that you represent. And so with that being said, we want to move into the Q&A, and we hope that all of our presenters are still with us so that we can directly or indirectly ask questions. I have some questions, and whoever feels like answering these questions, feel free to jump in so that we can recognize you and we can begin. So with that being said, I just ask my colleagues to I'll give you a few moments right after I ask these first questions to chime in, and we'll recognize you, and then you can proceed with your questions, whomever you want to, or just a general question for whoever wants and feel capable of answering that question. So with that being said, to what extent do departments value community input in the internal investigation process? Again, to what extent do departments value community input into internal investigations process? So whoever would like to take that question, feel free to do that. Let me go to, is there a chief with us? Chief Ram?
Yeah, Chairman. Yeah, I can answer that specifically. You know, I've worked in 2 different agencies. I can tell you it depends on the level of management. Chiefs and sheriffs always value community input. Line officers, not so much. But I believe that, you know, I, as a chief of police, particularly here in Los Angeles, value community input. And as I listen to the attorney, the civil litigation attorney, talk about various ways to receive complaints, and we understand that position clearly, where people are afraid to bring forth complaints to, you know, to the very people that are supposed to investigate them. And we understand that the trepidation. And so, you know, there are a number of ways to bring forth allegations of misconduct through the internet, through third party, through the inspector general, through the district attorney, and other vehicles. But I think community input is really, really important, particularly as we move forward into the future, where people understand that we are willing to listen and be objective about their concerns. And I can tell you, being a young man who's grown up here in the inner city all my life and walked on both sides of the aisle there, that often it's felt that we as law enforcement do not take these allegations seriously. So I want to make sure that moving forward in the future, that, you know, policies be enacted where people are allowed to voice their opinion. So we have the Commission on Civilian Oversight Commission here in Los Angeles, and I think that's an important tool here to allow community members to come voice their concerns.
Thank you very much.
Mr. Chairman?
Yes.
If I may, this is Attorney Harris. I love what the chief just said, and he's an example of the kind of public official who gets it. In Sacramento, where I live, as I mentioned before, I can admit this now because he's about to retire at the end of the month. Chief Hahn and I communicated on a regular basis. You know, there were many people who thought we were adversaries. We were both trying to do the same thing, bring about justice on behalf of Sacramento. So I would hit him directly with text late at night or on the weekends. It's the will of the chief. The chief is the one who sets the tone. And this chief who just spoke is a perfect example of that. So I would commend him for that. I would say that you can have as many inspector generals and as many processes as you want. If at the top of the food chain, the chief is not committed, you're not going to see changes to this process.
One of the things that I want to bring up, and whoever wants to chime in, is that I don't think people have a problem with making complaints to law enforcement. I think there's a factor that are in fact intimidated to make a complaint. But it's those who actually step up to the plate and lodge a complaint and hear nothing, hear no follow through. That's where I think that we get the mistrust, the sweeping on the rug, and people feel that their complaint goes unanswered. And I think that there needs to be a process in which there's some follow-up, there's at least a callback or conclusion as it relates to one's complaint, so people doesn't feel that it's fallen on deaf ears. So if anyone wants to chime in on that, then I have another follow-up question, and then I'll have my colleagues, we'll just do a bouncing back and forth.
So, Mr. Chairman?
Yes.
On your last comment, that's provided for in the law as we speak in and the 832 et sec statute, there is information that's required to be returned to the complainant. And I want to assure the committee on behalf of my clients, they're very mindful and concerned about maintaining public confidence and doing things the right way and being a part of this process as a stakeholder. I also want to make clear a couple other things in terms of citizens coming forward and making complaints. There's a multiplicity of avenues for them to do that. Here in Sacramento, where our primary office is, there is outside civilian investigation bureau that reviews every internal affairs case, participates in that process, issues a report at the end of the year, and they have their own complaint procedures for receiving complaints. The city can receive complaints, and they have hotlines to do that outside of the police department. The police department can receive complaints, and they can be criminal complaints that then also get referred over to internal affairs, depending on the nature of the complaint. Internal affairs has its own website and telephone numbers for receiving complaints. The district attorney's office can receive complaints, and they'll refer them back to the internal affairs. You have also the lawsuits that were mentioned by one of the panelists, but filing a civil lawsuit is not the primary trigger for initiating an internal affairs complaint. It's these other processes, and it's not something complicated. There's no lawyer that's needed. There's no complaint that has to be drafted. It can be as simple as a short, in common vernacular, email or a telephone call. And I think it's also important when we're talking about potentially changing longstanding and traditional rights that people have to due process and fairness in the process. And that's what this is really about. This isn't about helping somebody get away with something. If the agencies follow the rules, these are basic things that you have an opportunity to have a representative record your interview and that you have due process, then there is no violation. And we've made meaningful reforms. And I want to point you to SB2. SB2 creates another pathway for citizens to file a complaint and another layer of review through post and through a civilian advisory panel that once they receive the complaint, they monitor the internal affairs complaint, they have access to that, and they even have the ability to conduct their own investigation. So, I would respectfully disagree that in terms of there being an inability for citizens to make a complaint. I'm mindful that people are hesitant to come forward, but I'd also point out that there's no penalty for someone making a false complaint against a peace officer in this state. In other states, they have to attest under penalty of perjury, and there's potentially criminal or civil liability that attaches for making a false complaint. And we can't go into this just assuming that every complaint is truthful, or even if somebody sincerely believes something, that it actually is misconduct.
Can I chime in on a little bit? And Dave, thank you for that. One thing I think that's really missing here is the fact that in very small complaints, citizens really just want someone to listen to them, and they want the feedback. The feedback that we do give folks in those documents is very, very sanitized and very administrative. It doesn't really say a lot. It just says that the misconduct was unfounded or founded, and the appropriate administrative action will take place. What people really want in the community, is, you set my grandmother on the curb, and we don't really appreciate that. And we want the officers or the deputies fired for these kinds of things. Or we simply just want that to stop and for you guys to recognize this is inappropriate behavior for policing our community. And so there really has to be some follow-up dialogue, not only with the chief, who will lead that by example, but also with all those subordinate supervisors that he or she selects to be their local station command folks, because you have to be embracing of the community. And there's these communication breakdowns that really were law enforcement personnel tends to be very, very defensive of their officers and their deputies, when really there should be more dialogue and communication where people are, given a chance to be heard out.
Great. We're going to go to member.
If I could just follow up on that real quick. To Chief Rambo's point and to Mr. Mastagni's point, there are already provisions in the law to provide a response to the complainant. I will say what the department can report back to the complainant is limited because of the PITJA statutes. There is only so much that can be said because officer records do have confidentiality attached to them because of those statutes. And so to the chief's point, it is a rather sanitized version, which can, I think, be unsatisfying in to some people.
Great. We're going to go to Mr. Lackey.
Yeah, I think it's important to speak to one issue that's not getting any discussion. It just got briefly mentioned by Mr. Nastagny, but as false complaints. You got to remember, as a member of law enforcement, complaints are a serious thing with my agency, and we do take them very serious, and they are documented, and there is a requirement to notify. But I can't speak to all agencies, and I think it is a very delicate topic. But there is such a thing as a false complaint, and there are a significant amount of people who want to use the complaint process as retribution or as a tool to punish an officer unfairly because they felt like circumstances that brought them into custody were disturbing. And I think that there is that reality that needs to at least be considered, that you do have a large number of people who they already have an animus, a bad feeling towards law enforcement, and they are going to use this procedure in an inappropriate way. And we need to recognize that that is a fact. It's not a prevailing fact, but it is a fact that deserves at least consideration.
Thank you very much. I heard a female's voice. So, Maria, was that your voice that you wanted to chime in?
That was. I was just
Yes.
going to make 2 quick points to pick up on the prior set of comments. So first, this is actually something that the legislature can do something about. So partly it does fall to chiefs to engage better with their communities, but there's lots of room for the legislature to, require agencies to give people an opportunity to cure a complaint that, people maybe didn't provide enough information, and so the agency can't follow up, and you can have an obligation to get back in touch and give people an opportunity to cure. And of course, you can also tweak the law that makes it so difficult to actually give people adequate information about what really happened with their complaint, getting the sort of, sanitized description of, it was unfounded without any sort of explanation of why or what happened, really does undermine any sort of faith in the disciplinary process. So this just strikes me as a clear area where there's more that could be done legislatively.
Thank you very much. I want to go to my colleague, Kevin McCarthy.
Thank you, Mr. Chair of this committee. And I wasn't here at the outset, but I did want to say, first of all, I listened to all of it from the beginning on my phone. But I really wanted to, thank you for creating this a year and a half ago. We've had, half a dozen or so hearings, and not just talking, but bringing about real ideas. And so I know that some of the bills that we passed, we talked about a year ago in this committee. I know we talked about the SB2 issue of decertifying officers that cross the line. And so, we have done a lot in California, half a dozen or so bills. I know your landmark bill on the chokehold, the bill we worked on with Dr. Weber on use of force, my bills on independent investigations and sheriff oversight, Mr. Holden's bill on duty to intervene, and the records bills that Skinner has done twice. Mm-hmm. Those are very significant in bringing about fair policing to both law enforcement and our community. So we have done a lot. Some of the issues on these bills overarching have made the issue of the Peace Officer Bill of Rights better, POBAR. And I think that the two of those issues that when we talked about POBAR years ago, some of the issues that we talked about, the weaknesses were holding officers accountable who bounce around, investigations, transparency with discipline records. So those, have been addressed. And I think I really appreciated what Chief Rambo talked about in his experience. He gave us a history lesson that when this was first put into law in California, not only was it signed by Governor Brown, but it was endorsed by the ACLU. opposed by the chiefs. And so mindful of that. So I haven't seen anybody propose in writing a bill to end POBAR. Maybe somebody will. I haven't heard that, but does it mean we shouldn't mend it, right? Maybe there's certain things that we need to do, like every other thing. Well, CEQA, every other major document we have here is a living, breathing thing. Times have changed. It's been utilized differently by whether they're individual jurisdictions through their contracts and their MOUs with their local law enforcement agency. I do understand that. I know we don't have, as far as one of our panelists here, the ACLU, who we did mention early on. So I have two issues I want to talk about, Mr. Chair. One is the statute of limitations issue, and one is how this relates to all other employees, which was suggested. So first, we've heard different opinions on the issue of the statute of limitations. The speaker representing the Liebert law firm, who works with agencies, talked about the flaws in the exemptions for potential tolling, where there are some will slip through the cracks and there won't be an opportunity to hold individuals accountable for wrongdoing. Of course, the attorney for our local peace officers here in Sacramento, and I believe PORAC in California, Mr. Mastagni, talked about how he thinks that it's sufficient. I guess my first question is for Mr. Mastagni. The question is, what would be the flaw, or what would be the harm if the statute of limitations was changed from a year to 2 years or 3 years, or any change at all? What's the potential public policy harm in your eyes?
I think that the current law strikes the right balance. And Mr. McCarty, I don't know if you saw my presentation comparing the different statutes, but it runs from when somebody makes a complaint, not from when the conduct occurred. So in practice, it's not 1 year from when the incident occurred. It's 1 year from when the agency was made aware of the misconduct. And frankly, I think if you're talking about serious misconduct and an agency wants to take more than 1 year to determine whether or not that officer is fit, it's outrageous, and it's in the public interest that that investigation is timely completed. And in my experience, it's not been the serious allegations of misconduct. It's been the really minor stuff where agencies blow it off because they're triaging, or they don't think it's important. It's like missing cord or something like that. That's not going to be career threatening. But just from a good employer standpoint, if you've got an employee that's performing at a deficient level, this is just basic, is you need to put that employee on notice, whether it's McDonald's or whether it's a police department, that they're not meeting standards and that you need to get up to standards and go through progressive discipline. It does nobody any good to just let things linger for beyond a year. And I can't think of any circumstance where an agency wouldn't be able to do it. I've never seen in my 22 years of practice a serious allegation like a use of force or a sex assault or anything that's covered by SB2 or the disclosure statutes go beyond a year. It's been minor stuff.
So your argument that by the harm, you're saying if it went to 2 years or greater, it would be the cloud over the officer's head who's accused of this? I'm trying to say, I know you're saying hypothetically it hasn't happened, but what's the downside in your perspective for people in law enforcement if it was extended?
So I was talking from the public's perspective, but thank you for that. From the officer's perspective, it does hang over your cloud, a cloud hanging over their head. And that officer, he or she, is typically not eligible to get any kind of specialty assignment, not eligible to promote or advancement. And it can be, frankly, used, and I'm excluding Chief Rambo here, of course, but there are some bad chiefs and there are some bad managers that will misuse the ability to do these things. And so they know that, for instance, that an allegation is unwarranted, but hold it over the officer's head indefinitely so that they're essentially blackballed, and you maybe push them out of the agency because their career is dead. They can't get into a specialty assignment that could lead to a promotion or something like that. I gave the example of Mike Ziegler, who had a gag order and a cloud put over his head simply for filing a grievance on behalf of Assemblymember Cooper when he was police captain. And so I think there's an interest on both sides in having these matters resolved timely. And that really, I haven't seen anything that would make an agency unable to do an investigation. If a complainant doesn't want to come forward or a witness doesn't want to come forward, they're not going to come forward. I mean, nobody can control that. But what the agency can control is that they can control the timing of reaching out to those witnesses. They can control the timing of the interrogation of the officer, who's their employees. And one thing, this is a little bit off topic, but I do want to make sure that the committee understands, under SB 2, and this is something PORAC advocated for, the employing agency has to complete an investigation even if an officer leaves and goes somewhere else, so that there's a final determination. And that, I'm not sure if it's 2022 or 2023, I'd have to refer to the statute, but is going to be coming into effect in the future. We have a shared interest from the labor side in wanting to have a timely conclusion of these investigations. And if an officer, isn't fit for duty and for the job, then appropriate action be taken, but not have it linger forever. And the public doesn't want to have it linger forever. If you have somebody who's not done something that disqualifies them from continued employment, but they're doing things in a substandard way, then they should be put on notice and they should be corrected timely. I mean, I use the example of, somebody who's got poor report writing. Well, if you wait over a year to tell them that they need to fix it or take remedial measures, they're just going to continue writing a year's worth of poor reports, and that doesn't do anybody any good.
Thank you for that answer. And
Mr.
I want
McCarty?
to go to Mr. Yes,
Before
Mr. Harris, and then I want to go to Mr.
Yeah.
Sheldon.
Attorney Harris here, Assemblymember McCarty. Mr. Mastagni, for all of his brilliance in his presentation, in representing what the people, he talked about the public, the community, if you will. I represent a different aspect of that community. I represent the people like the mother of Dejan Flanall, who was gunned down in Sacramento, and it took her emotionally months before she could get up the courage to even think about bringing a complaint forward on behalf of her dead son, who was shot dead and left in the middle of the streets of Sacramento. This isn't a clean and neat process for everybody. If you're talking about the unhoused community, you have all kinds of complexities you have to work through in terms of them being able to file a complaint. If you're talking about those who have intellectual disabilities, you've got to work through the time process. So while I share your opinion that you don't want a cloud hanging over the head of the officer, by the same token, all aspects of our community should be considered relative to the types of folks who tend to be victimized. It takes several months for a number of members of our community to even understand that they have certain rights and privileges, that they can even complain about these sorts of things. And finally, I'll say this. I always shake my head and scratch my brow, furrow my brow over the thought that we can't identify who the bad actors in our community are. You can go in any neighborhood in the community, if you will, throughout California, and ask the folks in the know who the bad cops are in terms of their behavior, who has a pattern and practice of behavior that is discriminatory, that is oppressive, that is violent, and they can show you right who they are and give you chapter and verse time after time after time again. So this isn't as difficult as one would make it out to be. What is difficult is being able to get people to feel confident, to feel seen, to feel credible in bringing these allegations forward.
Thank you, Mr. Harris. We'll go to Mr. McCarty to finish his.
Yeah, so thank you. I wanted to ask Mr. Harris and specifically Mr. Sheldon next about this issue. And so, yeah, Mr. Mastagni says in his recollection he doesn't see any case that the statute of limitations was not an issue. He says that even if there was an incident that happened, the 1 year statute doesn't start until the investigation starts. I'm sure there's plaintiff attorneys or the ACU that can point to other examples where the city may have dragged their feet, allowed the 1 year clock to tick, and an officer who, was accused of wrongdoing or did do something inappropriate in a community never faced any consequences. So Mr. Sheldon did talk about what he views as his feelings on shortcomings of the 1 year statute of limitations. So can we have Mr. Sheldon talk a bit more on this issue and your recommendations?
Sure. The concern I guess I have would be, when does the statute of limitations start running in the first instance? It's an easy call when a written complaint is submitted from a citizen. And to Mr. Mustagni's point, the POBR statute of limitations does not start running. So there is no impediment to holding the officer accountable until there is some sort of notification to the department. The rub, if you will, is there are some circumstances where there is information, and it usually happens in the scenario where the information comes to a supervisor officer, a sergeant, who, and in the Pedro versus City of Los Angeles case, again, I would encourage the community to read it. It's a good teaching tool, I think, on this point. But the information comes into a supervisor who needs to look into some things to determine whether a misconduct even occurred or not, whether this is a real complaint or not, and then who the officer might be. And in the Pedro case, the LAPD had to do some digging into just to figure out who the officer was in a particular patrol car, and it took them 10 or 11 days to do that. And because of that, they ultimately missed the statute of limitations just by a matter of a day or two. And the court ultimately held what the court ultimately held in the Pedro case was the department was on inquiry notice. And so it should have, the starting of that statute of limitations was 10 or 11 days earlier, because the sergeant should have known that he needed to start looking into who the individual was. And he was really the internal affairs investigator, if you will, not when the matter was ultimately signed to an investigator once they figured out who the officer involved in the potential misconduct was. And so I guess my main concern would be on that kind of the areas of what I call pre-investigation by a supervising officer, where they look into something they're not sure yet if misconduct even occurred, or if it did, who did it, who did the misconduct. And if that starts the statute of limitations, that can have draconian effects. And we do counsel our clients err on the side of caution in these areas. When did the first information come into the agency? But sometimes we don't know all of that, and we don't know that a sergeant received a phone call and didn't tell anybody or something like that. And so I think there's two ways of approaching it. One is to address the length of time, but also giving perhaps more clarity on when the starting of the statute of limitations actually kicks off.
Okay, thank you. And lastly, Mr. Chair, can we go to Professor Ponomarenko and ask her two questions? One, do you think there are impediments in California's implementation of this because of the year and what was just noticed when it starts? And two, what happens in other states as far as this? Is this a normal practice, or in other states is the statute of limitations much longer?
That's a great question. So I think on the first point, the concern really is around these ambiguous notifications. So it's when the agency either isn't sure, who the officer is. There's a case in California that made clear that once they're put on notice that something bad happened, even if they don't know who's responsible, that clock starts to run. And so I think clarifying that ambiguity would probably go a long way. As far as statutes of limitations, honestly, they vary quite a bit. So a lot of other LEOBOR states impose a 1-year statute of limitations. Some agencies have actually negotiated away even shorter ones under collective bargaining agreements. There are some that are, egregiously short. But I think the conventional wisdom is something in the 2 to 3 year range would give, adequate space for agencies to complete those investigations in those kind of cases where it might take a little while to really figure out what happened. The last point I just want to make is it really depends on remedy, right? So we want agencies to do these quickly. We want the public to be angry with their law enforcement agencies if they're dragging their feet. The question is, what are the consequences when an agency fails to investigate something within a 1-year limit? And if the consequence is that the officer gets off the hook, that's when you start to see a problem. And there's lots of other mechanisms for ensuring that agencies do this well, including, city council oversight, mayoral oversight, and other mechanisms, funding to speed things along.
Yeah, just concluding comments on this. I don't want to be looking looking for a problem, but I don't think I know enough. I don't think we know enough. I know that the law enforcement attorney, Mr. Mastagni, says there's not a problem. Everything's good in this front. But if there are individuals, officers that skated accountability because they ran out the clock, that's wrong. I think that's wrong for everybody. It makes the good officers look bad. And so, I think this is something worthy of exploration. And, with that, certainly something that I'll look into. But thank you, Mr. Gibson. That's all my questions.
Thank you, Professor Pomerenko. I want to have a follow-up question since you're still here, and appreciate you guys staying with us. When you look at, I know that Mr. Mastagni talked about in his presentation, which was eye-opening. He talked about the NRB. There's no NRB process for public employees. And then you look at POBAR itself. And then you also look at the question of, maybe I won't ask that question. So why do you don't think that public employees have such an NRB process within, because these are union. The police officers, POBAR is it's the same thing, giving employees rights, just like any other union collective bargaining agreement, right? One is set for private and one is set for public. But when you look at the magnitude of policing and the Peace Officer Bill of Rights, do you think the NRB could be a good place for them to end up? Does that make sense? Are you following the questioning?
I am. So, this goes a little bit beyond my expertise. I'm not a labor lawyer. I write about policing and kind of administrative government more broadly. I understand Mr. Mastagni to say that, in California, we actually have kind of an analogous set of public sector employee rights. I think the question for this committee to really focus on is how these sorts of rights play out in the context of policing, and particularly this kind of overlap between investigations and supervision, right? So, once a complaint is filed and there's a formal investigation against an officer, a lot of the rights that kick in with POBAR make a lot of sense. One of the concerns comes in this fuzzy gray area where, a supervisor hears that something bad just happened on a shift and they go out to, talk to an officer. And there's this ambiguity as to, is this just supervision? Is this something that really falls under POBAR? And, given the nature of policing and the hugely important role of supervision, I think one of the concerns with POBAR-like rights as they bleed into supervision is it erects barriers to kind of supervision and accountability that may not have as much traction in the context of, the bus driver or your other public sector employees. And so the impact of those rights might just be different in the policing context. But I'd love to hear more actually from the chief, might be in the best position to kind of speak to that and the degree to which he sees this as an impediment. Great,
because again, law enforcement is in fact have collective bargaining agreement, union rights, just like California is a labor, if you will, state. It's not a right to work state, and so we believe in the collective bargaining agreement, and so we have these collective bargaining agreements to protect the employee. And without that, we would see what we've seen in other states as relates to what we believe unjust terminations and things of that nature, because there isn't such in place. I want to ask Mr. Mastagni a question. In your presentation, sir, you talked about serious misconduct. Can you give us examples of what serious misconduct would kick into place under a peace officer's Bill of Rights? give us situations that this would automatically be implemented.
So if I understand your question correctly, it in the context of like the tolling agreement, for example, whatever allegation of misconduct is going to be subject to these basic procedural rights about notice and having an attorney there. If there's like, say you're talking about serious misconduct like use of force or use of deadly force, there's going to be a criminal investigation that is going to take primary over the administrative investigation. None of the POBAR rights are going to be in play on the criminal investigation, and all of the time on the 1-year statute of limitations is going to toll while that's going on. So the distinction that I'm trying to make is that on something serious, it's going to get investigated right away. The one instance I can recall of there ever being a violation of the 1-year time limitation, it was similar to what Mr. Sheldon was describing. It was a situation where officer was in an accident, reported it to his supervisor, who reported it to the traffic safety committee, who looked into it for about a month, and then they referred it over to internal affairs. And the department said, okay, a year from internal affairs, and they blew the time by a month. It's not something that's serious misconduct in the sense that an officer is going to get fired or there's allegations of criminal conduct on duty. It's something where I would ask, into all of these, is why wait till the last day on a year? If there's an officer that has an issue with their driving, you should remedy it immediately, or at least in a timely fashion. And that's really the question. And if you're waiting for the last day of a year and you're only doing it on the last day of the year from when you received the complaint because of this statute, what happens if you take that statute away? Then they'll just get around to it whenever they get around to it. Maybe it's 2 years later, maybe it's 3 years later. And what good does it do to discipline somebody for getting in a chargeable accident on duty 3 years after it happened? You want to send them to EVOC and get retrained in a prompt and a timely manner. And so that's the main distinction that I'm talking about. On terms of how I would define a serious misconduct, I think that the legislature has done a good job of that through the penal code has been amended now with SB 16, and there's a definition of what are serious misconduct. SB 2 also has a little bit less refined, but pretty similar type definitions. When you think about an officer, there's things that are potentially criminal is maybe it's not the only bright line, but it's a good way to look at it, versus there's things that are just performance issues. You're not driving great. You're not investigating great. You have a punctuality problem. Those are things that happen in every profession, and you don't fire somebody or criminally prosecute them for them, but you take corrective measures. Hey, you need to start showing up to work on time. If I had an employee that was showing up tardy every day, I wouldn't wait a year to tell them that they needed to improve their attendance.
So what I'm hearing, just for the public edification, is that POBAR kicks in just as you described. If a police officer gets in an accident, there's an investigation. He has to have union representation. POBAR is invoked in that particular scenario. However, when there is
I think that's a little.
I'm sorry?
I didn't mean to interrupt you. I think that's a little bit too broad. The statute actually defines it. It's when there's an allegation of misconduct or a questioning, really, on the procedural part, when there's a questioning by a supervisor that could lead to discipline from the perspective of the supervisor. So if a supervisor is going to an officer and saying, hey, you're doing a crummy job of report writing, I'm not going to discipline you, I'm just going to tell you to do better, then POBAR doesn't even come into play. That's just a routine counseling, and they have a right to do that. It's only when discipline is in the picture, is a layman's way of saying it. And it's from the supervisor's perspective. If they're looking at the officer for potential discipline, then they have to tell the officer, I'm looking at you for potential discipline, and you can have a rep, you can record it, etc.
It has to be formal discipline also. Formal, not informal.
Great. Big distinction. And so I'm glad you clarified that, because I think some people in the public would think that when it comes down to a police officer in allegation of a use of force or deadly force, then they believe, so I hear that they believe that POBAR kicks in and provides these rights that somehow would give them the upper hand, or people are silent or the investigation is not adhered to like it normally would. So I'm glad you were able to create those two distinctions. So when it comes down to use of force and deadly force, then POBAR is not invoked. Investigators come in, they do a thorough investigation of the situation. But as you described, again, POBAR is just like if a person is being called into your boss's office and the boss wants to provide discipline, the person has to have a right to have representation. The person has a right to have certain things under that particular purview that potentially could lead to discipline from a commanding officer and or a boss. Is that correct?
You nailed it, Mr. Chairman. When there's like a use of deadly force, it is a criminal investigation at that point. POBAR is not even in the picture. You typically are going to have the district attorney's office looking at that. If it's a 1506 case, then you're going to have the attorney general's office looking at it. And those are the people that are going to be conducting the investigation side by side with whatever the local law enforcement in the jurisdiction that it occurred in. And none of these rights apply. The only way that any of the Peace Officer Bill of Rights would come into play is if after that criminal investigation, separate from the decision about whether or not to charge the officer, the agency decides to fire the officer, then the appeal rights kick in. But as I had mentioned before, there's really not a lot of substance on the appeal rights in the statute. It's really just recognizing Skelly and the civil service system, which we have in this state. Kind of circle all the way back to your question about the NLRB, why it makes sense, in my view, to have representation rights and a civil service system for local government employees so that you don't have Tammany Hall, you don't have decisions being made based on nepotism or corruption, and that you have fairness. And I mean, at core, these are actually anti-discrimination statutes to make sure that everybody is treated the same and that there's a fair and impartial investigation, and that everybody is afforded due process.
I remember when I worked for UTLA and representing teachers, we had Skelly hearings and Skelly rights, and we had those that gives opportunities for both sides to make presentation, but most of all, in that you had representation. You had union representation, a union lawyer or a representative such as myself to go there and argue in support of that union member. Again, I think that's what makes us great in terms of being able to defend an employee. Mr. Lackey, Mr. McCarty, you have a follow-up question? Well, I have another question. Well, Mr. Sheldon, do you have anything that you want to weigh in before I ask another question? We want you to be part of the conversation as well.
Yeah, just for clarification, though, to your question about what is serious misconduct, SB2 did give us some definitions, statutory definitions that will be part of that bill that I believe many departments are, if they don't already, and I believe most of them do, incorporate those into their policy manuals as far as, what is significant misconduct. And and Post will be issuing, is my understanding, as part of this legislation, they'll be issuing further regulations which will further define what is to be considered serious misconduct. And the implications of this all mean what has to be reported to Post, because I think a lot of what you're talking about here, you've addressed quite a bit of this already with SB2. Some of the quote unquote flaws, if you will, that might be perceived within POBR. SB2, in my estimation, has addressed quite a bit of those. Again, the main concern I have from a chief's perspective, if you will, or at least an advisor to a chief, is that gray area of that. When the supervisor is looking into potential misconduct there, and I do agree with Mr. Mustagian. That's typically not going to happen when those high-profile, obvious misconduct, use of force, shooting type situations. It's the other stuff, and in my experience, it comes up when there's a question about the integrity or honesty of an officer. That's where I see it play out, and where it can be the negative consequences can play themselves out.
Great, thank you very much. I have a question, whoever would like to answer this question or address it. When it comes to questioning officers during an investigation, Who oversees the questions and how are they evaluated? When it comes to questioning officers during an investigation, who oversees the questions and how are they evaluated?
I could take a stab at that.
Sure.
The questions are completely the purview of the employing agency and their internal affairs investigators. And so the officer doesn't get a preview of the questions. The notice information is the nature of the allegations. It's at a very, very high level. It typically is one or two sentences. You used excessive force during the arrest of suspect or whatever, by their name or the report number, so the officer knows what the incident they're going to be questioned about. And then once they get in there, anything that's within the purview of that complaint or that incident is essentially fair game. And the investigators, it varies depending on the size and sophistication of the agency, but most agencies that are at least medium or large size have permanently assigned investigators that are very skilled at asking questions and developing questions. But the short answer is the employing agency has complete control over that. If an officer refuses to answer a question, they can be terminated for insubordination.
Mr. Chair, let me also chime in a little bit on that. One of the things that we, having been an IAEA investigator and the supervisor of IAEA investigators, is the quality of the questions usually are overseen by a supervisor in internal affairs. One of the things that we really caution our investigators on are asking leading questions. We like them to ask, open-ended questions. We also like them to ask specifically, did you do blah, rather than beat around the bush. And so the quality of the question, looking at depending on the allegations, are something that, usually is discussed ahead of time so that you can tailor your investigation to really get to the crux of the actual allegation and not veer too far off into speculation and other issues.
Let me have a follow-up question. Should a third party have the opportunity to evaluate the questions? Should a third party have an opportunity to evaluate the questions? I know that's very broad, but it doesn't have to be. Please.
If I can jump, if you're asking, should there be judicial oversight? I would actually love it because from my perspective, most investigators do a good job, to be fair, but sometimes they ask what I consider to be inappropriate questions or beyond the scope or delving into personal matters that are far afield from what's under investigation or ask for legal conclusions or things like that. And an IA investigation is not a court of law. It's not a deposition. Representing an officer, I can make an objection on the record, but I don't have the ability to instruct the officer not to answer the question or to go get a judge as a discovery referee like you would have in a deposition to interject on here. And so if I instruct my client not to answer a question and I'm wrong, then my client's going to probably get fired and I'm probably going to get sued for malpractice. So the amount of power and control that the agency and the investigators have is very, very disproportionately skewed against the officer compared to pretty much any other kind of a judicial proceeding or questioning that any other citizen would be subject to.
If I could just add to that,
Please.
I think it is unnecessary to have a third. As a practical matter, I think it would bog down the process to have the questions, if you will, screened by some third party. And as a practical matter, there is an opportunity for third party review, and it's through the discipline and the appeal process, and all the way, to the court system with the writ of administrative mandamus process. If the investigator goes overboard or is out of bounds, Mr. Mustagni can challenge that. He can challenge it in front of the hearing officer, in front of the Civil Service Commission, in front of the Personnel Board. And if they go along with the investigator and he still disagrees, he can take that up to the courts and they will address it there. And so, but it is all done after the fact, admittedly. I think trying to impose a third party at the interrogation stage, is only going to slow things down in the process. And a last point on this, while there are different qualities of investigators throughout the state of California, undoubtedly, most seek out special training to be an internal affairs investigator. Post provides trainings. I know there's a lot of training provided to these individuals. They go out of their way not to ask the leading questions. They're trained not to do those types of things. There are best practices, ways to conduct an effective, fair, and thorough investigation without violating the officer's rights, but also getting to the truth of the matter. And injecting just another layer, I think, would do probably more harm than good.
Mr. Chair, can I chime in for 2 seconds?
Sure, go right ahead, Chief Rambo.
So just to your point, I think what the point you're really trying to make is the integrity of the investigation, the integrity of the initial investigation on the onset. I think that as a chief, if I had a constitutional policing arm here inside the department that I'm in, or perhaps if I'm in the sheriff's department working with folks that are skilled attorneys, that particularly on serious cases, particularly like uses of force where a person has actually succumbed and passed away, I think it's important for the transparency part to consider maybe having someone of a third party say, we're looking at these questions, we're looking at how we're going to question the officer or the deputy involved in this particular incident. Therefore, it gives the people who are watching the investigation an idea that it's not just all done internally, and that there's no way for us to really skirt the issue or minimize what the allegations were, because they were looked at by like the constitutional policing part of the organization. So I think that's something that maybe is worthy of discussion at some point.
Sure. So let me just clarify. So should there be more of a consistent protocol as to what questions should be asked that have already been evaluated? Anyone wants to?
It would be. I think it would be really difficult. I mean, this really would be from the management side, and not my bailiwick, but it would be really difficult to come up with a standard set of questions because the complaints are so varied in nature and they're so fact specific that they. I mean, there's certain things, like most agencies will ask at the end of the investigation, they'll have the officers look at the policies that they're alleged to have violated, ask them if they violated it, and if not, why. And a lot of times in ways that I don't appreciate or like the formatting of the questions. But when it comes to you can't, I don't think, make just a checklist of all of the questions other than just the sort of introductory ones at the beginning, because it all turns on what's the nature of the complaint against the officer and what's the factual backdrop.
And I would add to that, what's the response of the officer or the witness who is being asked questions? That can change where the interrogation needs to go or not go. Also, with respect to Chief Rambo's comment about third parties, I don't disagree with that, but I think and correct me if I'm wrong, Chief, but when you seek the advice, if you will, of a constitutional policing advisor, that's internal within the organization. As I understood, the question was bringing third parties to evaluate the questions being posed. I think most agencies, particularly with higher level, more serious allegations, they do bring in lawyers, whether you call them constitutional policing advisors, employment attorneys, POBAR attorneys. There is that advice and counsel being sought about the nature of the questioning, the scope of the questioning, and that kind of thing. So I think that is happening. Sending it out to a third party, though, that is not affiliated with the agency, again, I do still believe that would bog down the process.
Thank you very much.
Also, just add, what Mr. Sheldon said is exactly true in my experience. You'll have city attorneys looking over the questionings before they make a decision on discipline, and it's often the city attorney will say, go back and re-interview the officer, get more information. Or you have civilian oversight at a lot of larger agencies where they're reviewing every internal affairs investigation and giving the same kind of input. both on a case-by-case basis and on an overall quality of investigation basis.
Thank you very much. For the public, you will be able to, again, chime in during the public comments, and we'll be asking you to call in. Let me repeat the number. It's 877-692-8957. The access code is 1315-4202. So again, we'll be going to you in about 10 minutes or so. But I want to follow and continue all along the lines of the investigation. Are there investigations that does not meet required time frame to complete an investigation? If so, how does that hurt police accountability? Would you please answer with a state wide perspective, not just like a singular department perspective? Does that make sense?
I'm not understanding the question. Maybe could you state it?
Yeah, let me repeat again. Are there investigations that does not meet the required time frame to complete an investigation? That's number one. And then if so, how does that hurt police accountability?
Mr. Chairman, so POBAR actually dictates the time limit. So if an officer has or deputies under investigation for misconduct, the 1-year statute stands from date of department knowledge. And I can't think of any other investigation outside of a criminal investigation that the time is told. So unless Dave or the other attorneys have more information than that, I don't think there's any investigation outside of that for police misconduct that has no limitation on investigation.
Thank you.
I agree. And I don't think it, as I've said before, I don't think it poses a problem. I think where, like Mr. Sheldon's talking about, where you maybe have a confusion over a number, a couple days here or there, it's really just human nature to procrastinate, which I think I've made clear, I think is against the public interest to procrastinate on getting a determination. I understand, believe me, that the agencies, my clients, the chiefs, and everybody in between are busy and have a lot of irons in the fire, but I think it's important to get these investigations completed. And probably if you shortened it to 6 months, it'd be the exact same thing, but at that 6 month time period. Here, if you do have something that is complicated and requires additional time, there's ample grounds for tolling. I mean, it's as simple as more than one officer involved is grounds for tolling. Any kind of a criminal investigation aspect, which is going to be, any kind of deadly force, serious misconduct, civil suit against the officer tolls it. I mean, there's so many exceptions that we kind of joke that it's barely there, but I do think it's important because at least for the procrastinating agencies, it puts a mark in the sand to have it done by this time.
Thank you very much. Next question is, when an officer has been investigated, does that information stays on the officer's record? And if so, what is the extent?
I'll take a stab at that one. The answer is yes, it does. If the findings are sustained against the officer, there will be some kind of corrective action taken depending on the severity of the misconduct. It can range, again, from counseling, which is non-disciplinary in nature. That probably is temporary in the individual's record. But anything that is considered formal discipline, which would be a written reprimand, a suspension, a demotion, termination of employment. Those are generally speaking, the more significant disciplinary actions. Those are going to stay on the officer's record. There are at present agencies through the collective bargaining process that permit purging of officers' files after 5 years. And so some of those older disciplinary actions could theoretically be removed from the officer's file. That will be changing, at least with SB 16. My understanding that any sustained finding now needs to be kept a minimum of 15 years going forward. So To answer your question, they're going to be kept at least 15 years, and the legislature has already made a judgment call against sustained findings, non-sustained findings. I believe those records are mandated to be kept 5 years. So I think what this effectively means, though, is those MOU provisions that did allow for the purging of files will no longer be permissible, given the changes that are coming with SB 16.
Thank you very much. Professor Marengo, are you still with us?
Yeah.
Great. Thank you very much again. We're almost at the time where we will take public comment, but I must ask you a question. What do you see as it relates to POBAR? Would you suggest changing, making some amendments? What's your thoughts in that space, from your perspective as a professor at the university?
Sure. I think, as I said at the beginning, by and large, it's a fairly sensible set of procedural safeguards for officers, but I do think there's probably room for tweaking. So one thing that a number of states, including Illinois, have done is made much clearer the difference between a formal investigation and supervisory reviews, so that, those early kind of fact-finding questions that supervisors ask don't get wrapped up into the POBAR process. I think there's also, again, we've been discussing this at length, but reasonable questions around the statute of limitations, questions about whether all discipline should be appealable, or a number of states limit it to discipline of 30 days or more, suspensions of 10 days or more are appealable, and other things are dealt with in a somewhat more informal fashion. So I think there's room to tweak, and I would urge the committee to do that. But again, I would also urge that to the extent that you do tweak, I would be careful to make sure that you're tweaking not just POBAR itself, but also making sure that these same provisions don't just reappear in collective bargaining agreements. What we've seen in states without POBARs, it's a lot of the same restrictions, sometimes much stricter ones, that get negotiated away and end up being just as much of an impediment to accountability in the state.
Thank you very much. Mr. Sheldon, recommendations that you would like to see?
I actually agree with the professor. I don't think the baby needs to be thrown out. There can be some tweakings around the gray area about that pre-investigation investigation stage. I think clarity there is really needed. It's fine if you don't want to change the 1-year statute of limitations. That Mr. Mustagi makes great points. You don't want this hanging over an officer's head, and you want to give the department motivation to complete the investigation. But everybody should be clear when that clock starts running, and I think giving us some clarity on that would be welcome. Also, I think the remedy provision of POBAR should be addressed at some level about, what is the appropriate remedy when there is a violation of the POBAR. In all cases, should evidence be suppressed or discipline overturned because there's been a minor technical violation of the act? I think intent matters, or should matter, and that's something that I think, to the extent the committee is going to look at things about tweaking the act, that's an area where I think would be welcomed in my opinion.
Thank you.
And then lastly, I do agree with the professor that if you are going to make changes, you do also want to address the collective bargaining statutes as well. So there can't be individual agencies who just contract around what the law is.
Thank you very much. I want to go to Chief Rambo for any recommendations you may have, and then I'll do the same for Mr. Mustagni, and then we will move to the public comment section of the agenda.
Sure, just very briefly, concerning the statute of limitations, I certainly would not consider shortening that. One of the things I can tell you is that there is a motivation to do these investigations within a timely manner now that we have the 1-year statute. You have to take into consideration the size of the organization. My organization is a little over 1,100 folks. Some agencies are large as 18,000. So you have naturally more employees, you'll have more cases going in. Most internal affairs bureaus are not very large, and so the number of cases that investigators have to handle, just like any other, like criminal investigators, it can be overwhelming. And so you want to make sure that it's manageable. And then I concur with the comments of the other folks that just chimed in.
Thank you very much, Chief. Mr. Mustagny, any recommendations?
Yeah, as I said in my presentation, my recommendation would be to codify these union rights for all public employees and put them either in the various labor statutes like Myers-Brown, Dills Act, et cetera, or just in another section of the government code. I did want to touch just on 2 points that were raised by some of the other speakers. With respect to due process, the statute doesn't specify what gets appealed and what doesn't get appealed. That's a matter of constitutional law. And going all the way back to Skelly and what our Supreme Court has said is that the nature of the deprivation determines the level of due process that's required. So, for instance, yes, you can appeal a letter of reprimand, but only if it says it's going to be used against you in the future. And the appeal is a meeting with the supervisor that issued it or somebody that has the authority to overturn it. It's not an evidentiary hearing. It's not an expensive or cumbersome process as compared to a termination or suspension or something of that nature. With respect to the remedy, I respectfully disagree with Mr. Sheldon on some points. Under the statute, it definitely says that the court can fashion a remedy, but it's not automatic. Other Bill of Rights in other states, it is automatic that if you commit a violation, then X happens, the case is thrown out or evidence is suppressed. I have not seen a case thrown out because of procedural violation. Typically, what the courts will do is, I think Labia was one of the seminal cases on this, is they apply a criminal type standard. Like if you interrogated somebody without allowing them to have a rep, you can't use that interrogation against them, but you can re-notice them and give them a proper interrogation with a rep, and you can still discipline them. And I've had cases where that's happened and the statement is thrown out, but the court says that's all that happens. Court has broad discretion, but they will typically say that's all that happens. You can proceed with the case with everything else that you have except for the ill-gotten statement, which typically it's not much of a remedy to my clients. It's really more just holding the agency's feet to the fire because they can go re-interview them and get those statements. And there have been court cases where the courts have come down and said that there was a violation of the POBR and told the agency, essentially don't do this again and given them a warning, but then said that based on the things Mr. Sheldon was talking about, the intent and was it a mistake and all of those factors, that we're not going to provide a recourse or a remedy beyond just telling the agency not to do it again. So just in conclusion, I think that these are simple, fair, basic fairness and basic due process rights that should be codified for all public employees in California, and that California should lead the way on these labor issues.
Thank you very much. We appreciate each of you. We ask you to stand by. We're going to move to public comment. We would ask that any member of the public wishing to address this body, we would ask you please approach the microphone. Please don't touch it. We have people who will adjust the microphone for you. And then you please proceed in asking your question. We ask that you certainly be respectful of the presenters and also those on the dais with respect to your comments. So with that, if you could please state your name and approach the microphone.
Good morning,
we need you to come a little closer. Yeah. Proceed.
Good morning, Mr. Chair and members. My name is Rusko Kayangyang. I serve as a legislative aide to Javanka Beckles, who was a Richmond City Council member, now Alameda Contra Costa County Transit Director. Speaking on her behalf, I'm also speaking on behalf of the Perez family who lost their son, Petey Perez, to the police years ago. We worked with Kishana Harley and community members on a council resolution in Richmond, which passed 3 years to this day, calling upon the state to introduce policy changes such as changing use of force. Thankfully, it's law now. We still have more policy changes to enact true police reform, such as establishing stronger civilian oversight boards that have disciplinary powers so that law enforcement officers are held accountable in the communities they serve, to ensuring that the investigation process includes immediate and regular drug and other toxicology testing on officers, and unedited civilian video recordings that should be considered as evidence. To police unions should bear the cost of the paid administrative leave of any investigation. And finally, Maryland earlier this year repealed the Police Officer Bill of Rights, and it's time that the state consider repealing the Police Officer Bill of Rights. How come there should be a special protections for one class when what about the rest of us? Thank you.
Thank you very much for your comments. We appreciate that. Ma'am, would you please step up to the microphone and state your name and begin to share with us what's on your heart?
Thank you, Attorney Gibson. I'm not attorney, Representative Gibson. Thinking of a lot of attorneys. My name is Katina Perry, and I represent all of those who have been sexually violated by the sheriff's departments. In 2018, I was sexually violated in the El Dorado County South Lake Tahoe jail by Officer Green. When that happened to me, there were two other officers that was doing backwatch. Allegedly, the cameras were not working the day that I was sexually assaulted in the waiting room, waiting to see my son. However, they didn't want me to fill out a grievance form because the officer, he wanted to literally take care of the issue himself. However, no, I wanted the grievance form. I wanted to grievance what had happened because they've already beat my son because we didn't take El Dorado County's district attorney's deal. So I thought, what else could they do to us besides what they just did? Besides beat my son, having been incarcerated for 82 days inside of a maximum confinement out every other day for 15 minutes. What else could they do to us? They did more than that. However, as I began to with my process, literally, the internal affairs of El Dorado County, they took 2 years to investigate my claim. However, they came back with no findings because they was going to cover their own people. And that's exactly what they said. I went to the EEOC and began to fight with them. The EEOC had said, it's going to be hard to fight up against this county and the sheriff's officers because their records are closed. I am glad that this bill is coming forth to be able to open the records of officers so I too can revisit what has happened to me and thousands of other people who has been literally sexually violated against the jail system for what? Because we didn't take your deal. So there's retaliation against not only the person that's inside of the jail, but the family members involved. So thank you so much for bringing this bill forth. I look forward to going forth against El Dorado County with all that I have within me to be able to resolve this issue and the issue for many others. Thank you.
Thank you very much for your comments and your comments around the bill. Is there any other individual in the audience who wishing to address this body? Seeing and hearing none, we want to open the phone lines up. Operator, would you please open the phone lines up and begin to allow the first person in the queue to address this body? You have 2 to 3 minutes to make your comments.
And ladies and gentlemen, if you do have comments from the public side, please press 1, then 0 on your touch-tone phone. An AT&T specialist will provide you your line number, and we will call your line number when your line is open. If you're on a speakerphone, please pick up your handset and make certain your phone is unmuted before pressing any buttons. We will first go to line 13. Go ahead, please.
Hi, line 13. Am I line 13?
Your line 13.
Your line is open. Go ahead, please.
Thank you. Reading from a California Globe article from June 12, 2020, Without law enforcement, there is no law, and without law, there is no civilization. Tom McClintock. We have recently suffered multiple failures of law enforcement, beginning with the killing of George Floyd. He died because a rogue cop who, despite multiple misconduct complaints, remained on a police force, as did one of his accomplices. This has become an intolerable pattern in our big city police forces, and we need to ask how politically powerful police unions and the politicians they maintain in office protect the bullies in the system that inevitably leads to atrocities like this. The other failure was the decision to withhold police protection from their citizens by mayors and their appointed police chiefs. That failure killed Pat Underwood, David Dorn, and so many other innocent victims in the ensuing riots. With withdrawing police protection from our streets, abandoning police stations to rioters, turning a blind eye to looting, arson, and mayhem, all have an incendiary effect on insurrections. Without law enforcement, there is no law. And without law, there is no civilization. An accounting of the deaths and destruction caused by these acts of dereliction of duty is yet to be tallied, but it will be staggering. We meet today to chart a course forward. We can look to no better guide than Sir Robert Peel, the father of modern policing, who set forth principles of law enforcement for a free society nearly 2 centuries ago. When you read them, you realize how far we've drifted from these moorings. Central to our discussion is his 7th principle, to maintain at all times a relationship with the public that gives reality to the historic tradition that the police are the public and that the public are the police being only members of the public who are paid to give full-time attention to duties which are incumbent on every citizen in the interests of community welfare and existence. How do we get back to these principles? There are many reforms proposed that merit support. First, the doctrine of qualified immunity, as currently applied, has no place in a nation ruled by law. For every right, there must be a remedy, and qualified immunity prevents a remedy for those whose rights have been violated by officials holding a public trust. This reform should apply as much to the rogue cop who targets people because of their race as it does to IRS or Justice Department officials who target people because of their politics. Reforming qualified immunity simply holds public officials to the same standards as any other citizen exercising the same powers. Second, police records must be open to the public. It is a well-established principle that public servants work for the public, and the public has a right to know what they're doing with the authority the public has loaned them. And police departments should be able to dismiss bad officers without interference from their unions. By preventing the public from access to these records and by preventing departments from acting on them, we destroy the very foundations of successful policing in a free society, public trust and accountability.
Thank you very much.
Turning police departments into...
Thank you very much for your comments. Next caller. Operator, please.
We will move on to line 11. Go ahead, please.
Hi, good afternoon. Can you hear me?
Yes.
Or should I say good morning? Sorry about that. Good morning, Chair and Chair members. My name is Sharina Latch, and I'm calling from Placer County. I'm calling in support of our police officers. I am very concerned on how this committee, testifiers, and the media have portrayed law enforcement to the public. According to police stats, there are approximately 1 million law enforcement officers in the U.S., and only 1% is estimated to be corrupt. How low is that? My grandfather was an HP officer and highly respected for never having to pull a gun in his 24-year career. Yes, he never pulled a gun. What kind of training did he have? Or maybe acts of crimes or violence against us has increased. I think it's interesting that no one is addressing education for our officers. I think that what this committee needs to focus on is how much training cadets get. Instead of a 6-month program, maybe extending the training program to 18 months. What kind of psychology or psychological evaluations do officers receive before or after their certification? Sorry about that. To be a police officer, it is one of the most difficult jobs in the world. And maybe criminals or people breaking the law should be more penalized than punishing officers for doing theirs. Because what a waste of time and money it is to keep arresting repeat offenders that judges let go on the streets. Crime rates in San Francisco and LA have significantly increased since Newsom passed Proposition 47. This is the stupidest bill on the planet. Talk about misconduct. You guys need to amend this. You're risking the lives of citizens and the officers that defend us. Stop defunding our police and protect their families as well. There should be some kind of reprimand for false reporting. Thank you.
Thank you very much. Operator, next caller, please.
We have no other lines in queue at this time.
Thank you very much. Let me bring it back to my colleagues for any final thoughts or comments. But before we do that, I want to thank the panel for taking time out of your busy schedule and giving this very robust conversation as it relates to the next steps, understanding peace officers' Bill of Rights. I think you've shared a great deal of light, and I've really and thoroughly enjoyed the discussion and the education. In the education that we've had today here in this hearing, Select Committee on Police Reform. And so I want to again thank each and every one of you. We look forward to you engaging with us again in the future and appreciate all that you've brought to light. So with that, I want to turn it over to my colleagues. Whoever want to go first? I'll go. Okay, Mr. Lackey and then Mr. McCarty.
Well, I too would like to thank the panel members for their insightful input. Understanding Peace Officer Bill of Rights was the main function of today's hearing, as I understand it. And it's my opinion that we had some meaningful discussion, which allowed clarifying and defining information that I wish the rest of the public clearly understood, because Peace Officer Bill of Rights has been characterized in a way that's very much misunderstood. And I'm hoping that we as legislative members will make decisions that will not only build public trust to help bridge the current divide, but will also support fairness to our public safety professionals. And I think we're on the path to doing that. Thank you.
Thank you very much. Mr. McCarty? Mr. McCarty said he's good, complete. Again, I want to thank my colleagues. I also want to extend a special gratitude to our fearless leader, my dear friend, Speaker Anthony Rendon, for allowing us to have such a select committee on police reform. Again, we've done, as Mr. McCarty has already indicated during his opening remarks, we've been doing this for about a year and a half. And through this process, it has not been one-sided. It has been open, transparent. We have heard from people who want to testify, both from the in-person and those who wish to call in and testify. Your comments have not fallen on deaf ears, and I think the evidence of that is that we've engaged with a very collaborative core group of individuals and the governor. Through that, the governor, there was 20 bills that went through the legislative process this year in 2021. 8 of those 20 bills wound up on the governor's desk. The governor signed those 8 bills into law. As we look at California and as we look at police reform, we are reimagining what police reform looks like in the state of California. It has not been one-sided. It has been stakeholders at the table hammering out language on all sides to hammer out what we will see enacted in 2022, 8 pieces of legislation. Whether that legislation speaks in terms of raising the age limit to 21 years of age with a college degree, whether that leads or that has led to decertification process, more transparency in police records, duty to failure to intervene, and also prohibiting police officer gangs, and also banning the restraints that led or leads to positional asphyxia. And so, again, we have heard you in terms of your voice. We want to continue to have this dialogue because we believe it's meaningful. And again, I want to thank Speaker Anthony Rendon for giving us this space to be able to tackle these very important issues. These are not simple issues. These are very complex issues. We've had a number of authoritative individuals, leaders from all over the country, experts from law schools, professors, legal minds, police unions, police chiefs, rank and file, but also community people, Black Lives Matters and others engaged in these conversations with us, and also victims, those who have lost their loved ones at the hands of police officers. As one of the speakers mentioned, there's 1 million officers in the United States of America, and 1% of those 1 million people are bad apples. Well, we want to make it uncomfortable. We want to make sure those bad apples does not reflect, and again, does not reflect what the good police officers who sign to become police officers do day in and day out, and that is to serve and protect. And we want to make sure that that is brought to the forefront of the line. The subject matter, as I said, is complex. We've had challenges, but we meet those challenges by, one, having the dialogue that I think is meaningful on this select committee. And I, again, want to thank my colleagues, those who are also, all of our staffs are watching this virtually. They are taking copious notes as we move through. And again, we can look at the work that we're doing and feel proud. There's still much work to do in this space, and I want to say I'm happy to chair the Select Committee on Police Reform. We'll continue to have issues and raise issues and have dialogue, publicly dialogue, to try to find answers to these problems, these very complex problems that face us in this state. So again, with that, I want to say to the staff, thank you very much, to our sergeants, and also to my team who's worked very hard to put this together, Brenda Contreras and my team. Thank you very much, Team Gibson. This Select Committee on Police Reform stands adjourned. Merry Christmas, have a Happy New Year.